Good day to everyone. This is the start of your pre-week review with me, and it will cover remedial law review. Okay, remedial law, the entire coverage of civil procedure, criminal procedure, evidence, and special proceedings. Please allow me to do it in 8 hours. This is the time allotment that I have considered. 3 hours for civil procedure, 2 hours for criminal procedure, 2 hours for evidence, and 1 hour for special proceedings. So with this, I'm ready to start. I hope you are ready to start. I know that at this time, when you're watching me now, you're done with 2 bar dates, meaning 2 bar days. And I hope that you still have the energy. You need energy now because this is the last part of the bar exams. And as you know, and as I have repeatedly said, remedial law review carries a very big load in the percentage in checking the bar exams. So please look at it as a final effort to complete the examinations, to pass it, and hopefully for some of you to top the bar. Okay? Now, having said that, let's start now with civil procedure. I would like to start with Republic Act 11576. No one goes to the bar exams without remembering the important amendments provided for in RA 11576. And there are two figures that you have to remember. The first one is an amount of 2 million pesos. And I hope by hearing this, you will immediately remember the things or those which you have to remember under this law. The first is for a claim, and that would include a money claim, that would include damages, which is principally the claim, and for a cover of personal property. So this 2 million, I would like to be very clear, excludes real property. I would like to be very clear, excludes real property. So here, please bear in mind that if the claim exceeds 2 million pesos, it will be the RTC, Regional Trial Court, which will have jurisdiction over that claim. Now, that amount is likewise important when we talk of probate of a will or settlement of an intestate estate. Kindly take note, where the estate's value exceeds 2 million pesos. That amount of 2 million is likewise relevant when we talk of admiralty and maritime cases. But those are not all of the cases that would fall within the jurisdiction of the RTC. Kindly take note that those which are incapable of pecuniary estimation are also with the RTC. Family law cases will also fall with the Regional Trial Court. Those which the law does not provide for a specific court where the dispute or controversy can be heard, it will be with the RTC, as provided for in BP 1.2. Now, another figure that you will have to remember would be assessed value of 400,000 pesos. I repeat, assessed value of 400,000 pesos. If the case involves Title II, possession or interest over real property, and the assessed value exceeds 400,000 pesos, I repeat, 400,000 pesos, it will be the Regional Trial Court. Regional Trial Court. Title II, possession or interest over real property. Now, let us now proceed with the jurisdiction of the MTC. Now, please bear in mind that those threshold amounts that I've mentioned a while ago are important also for MTC, Metropolitan Municipal Trial Court, Municipal Circuit Trial Court. For claims not exceeding 2 million, it will be with the MTC. Okay, to save time, I will just use MTC. It will be with the MTC. Okay. Now, of course, forcible entry, unlawful detainer will also be with the MTC. Take note, probate cases where the claim does not exceed 2 million, okay, 2 million and below. Estate cases, settlement of estate cases where the claim does not exceed 2 million, meaning 2 million and below. MTC. Okay? Admiralty cases where the value of the controversy does not exceed 2 million and below, MTC. Maliwanag ba yun? Maliwanag, ano ha? Now, again, when it involves title to possession or interest over real property, where the value does not exceed 400,000 pesos, meaning 400,000 pesos and below, MTC. Now, I just have to carve out a short discussion on possession. If it involves the material right of possession, which is forcible entry, unlawful detainer, or ejectment, if the action could be instituted within a period of 1 year from the time of dispossession, then it will be with the MTC. Regardless of what? Regardless of the claim for unpaid rentals. Take note that regardless of the claim for unpaid rentals. Now, there's just one thing, okay, I want you to be very careful about. Now, sir, does it mean that if I'm unable to file the action within the 1 year that you mentioned, I can no longer recover possession? But of course, you could recover possession. But if it's already outside of the 1 year period, or what we call action publicana, what happens? The jurisdiction is no longer automatically MTC. It's just automatically MTC if it involves forcible entry and unlawful detainer, meaning ejectment cases. But if it's an action for recovery of possession outside of this, meaning the period that already lapsed, you could still recover, but this time you will have to contend with the assessed value of the property when it comes to possession. You get me? The assessed value of the property, again, exceeding 400,000. It involves action publicana. It is with the RTC. Not exceeding 400,000 below, it will be with the MTC. Now you tell me, sir, pareho rin naman. Sabi mo, but class, you have to be very careful. There is a variance in terms of procedure. If it's purely an ejectment case under the expedited rules, it will follow the rules on summary procedure, expedited rules, in relation to Rule 70. If it is not an ejectment case, meaning it was not instituted, that is, the claim for recovery of possession was not instituted within 1 year from this possession, okay, you can still recover possession if the assessed value does not exceed 400,000 in the MTC, but it will have to go through what? Ordinary procedure. Ordinary procedure. Take note of what I said. Okay? MTC ordinary procedure, because it's no longer an ejectment case. Now, let me now discuss expedited rules. Okay? Ganun lang, ha? Tandaan niyo yung figures na binanggit ko sa inyo. Let's now walk you through expedited rules. Please bear in mind, class, and I would like you to please remember this. It's good that I still have a drawing here. Okay? It's good that I still have a drawing here. MTC, RTC. The only thing that you will have to watch out for, class, with the MTC is the procedure that is involved. It's clear the claim does not exceed 2 million, MTC. The assessed value of the property, title to possession or interest is the subject matter thereof. Assessed value 400,000 pesos and below of the property, MTC. But you will have to contend with this. Okay? In light of the expedited rules, summary procedure and small claims, which cases will fall under summary procedure? Listen. That which would fall under summary procedure will be those claims not exceeding what? Not exceeding 2 million, but exceeding 1 million. Summary procedure. Summary procedure and plans. Now, what else will fall under the rules of summary procedure? Listen, I'll help you remember this very easily. All actions, take note, in the MTC, I will repeat, all actions in the MTC will follow summary procedure. That's the general rule. Take note, huh? All will follow summary procedure except probate. Okay, except probate, even if the value of the estate is only 1.5 million, it will have to go through the procedure on special proceedings. Probate cannot be summary procedure. Take note. Admiralty maritime cases, because it has special rules, will always be with what? Will always be if the claim does not exceed 2 million MTC, but you will have to follow ordinary procedure in relation to Admiralty rules passed by the Supreme Court. Okay? Please bear in mind. Summary procedure also Excluded in summary procedure is also what? Small claims. No doubt. Yes, because in small claims, the claim for money or reimbursement for money does not exceed 1 million, meaning 1 million and below small claims. So hindi rin summary procedure yon. That which involves Title 2, as I mentioned to you a while ago, Title 2, possession or interest over real property, does not exceed 400,000. Even if the assessed value is only 200,000, it's always what ordinary procedure, Title 2, possession or interest over real property. Sir, now I challenge you, class. Read through the expedited rules. There is no mention of that. Sir, bakit ganon? Clearly, class, there is no mention of that in the enumeration. It would fall on other cases not included in the enumeration, which involves Title 2, possession of interest over real property, an amount not exceeding 400,000 assessed value. Are you clear? Okay. Now, let us now proceed with small claims. Now, kindly take note that for small claims, it is for reimbursement of sum of money. And kindly take note, if there is a claim for money, but there is a prayer for a provisional remedy, it cannot be small claims. Take note, huh? If there is a prayer for provisional remedies, it could not be small claims. Now, let me now proceed, okay? Let me now proceed to this. What are the subject of a sum of money case for reimbursement of money? Those which are arising from a contract of lease, from a contract of loan or other credit accommodation, for a contract of services, or for a contract of sale of personal property. Excluding what? Recovery of personal property. Kindly take note. So even if the subject of the dispute is a car, where the value of which is 500,000 pesos, you would like to recover the car, possession of the car, not to recover the value thereof, meaning wanting to recover the consideration for the purchase of the car. If it is what you intend is to recover the car, then it cannot be on small claims. Yes, you could still do it if the value of the car is 500,000. You can still file it in the MTC, but it will have to go through summary procedure. So now, you will ask me, what if the car to be recovered is worth 1.5 million? No problem. It's still with the MTC, but it will have to follow summary procedure. So if it's a recovery of a car, cannot really be fall under small claims. Okay? Can you take note of that? Now, those which are subject of a barangay settlement agreement or arbitration award on the barangay level, where the amount does not exceed 1 million pesos and there has been no execution within a period of 6 months, then class, it could be subject of a small claims action. Okay, class, it could be subject of a small claims action. Now, let us now proceed to my next point. I hope you're still with me. We will now discuss the rule problem. Okay, pag-usapan na natin yan. Sir, ang dami pa class regular review, na-discuss ko na, balikan nyo yun. Okay, but these are the things which I think are especially important at this time when you have only limited time. Okay, now, let us now proceed with the difference between an ordinary civil action and a special civil action. Now, class, always remember this. Rule 2, Section 1. Every ordinary civil action must have a cause of action. I repeat, every ordinary civil action must have a cause of action. So here there must be a breach or a violation of a right. And because of that, you seek redress from the court. You file an action in court. Ordinary civil action. And that leads me to the requisites of a cause of action. There must be the right of the plaintiff. There is the duty of the defendant to respect that right. And number 3, there is a breach or violation thereof. That is ordinary civil action. There is also what you call special civil actions. Special civil actions are covered by special rules. Okay, special rules under Rule 62 to 71. I will discuss those much later on. I take note. But these are covered by special rules. But the key here, according to Rule 1, is that you will have to abide, you will have to follow the rules. For example, it's interpreter. The case is interpreter. You will have to follow that. It's for declaratory relief. You have to look at Rule 63. If it's coercive, you have to look at Rule 66. Only when it is inadequate or incomplete can you refer to the what? Ordinary procedure, ordinary rules. I hope that's clear. And in addition to that, special civil actions are what you call original actions. These are not appeals, these are original actions, as differentiated from an ordinary civil action, which is rooted on breach or violation. A special civil action is not necessarily rooted in breach. Class. Although there is one specific rule, which is Rule 70, which is unlawful detainment if there is failure to comply. There was non-payment, class, where there was non-payment of the rentals, and there is a demand, there is already a breach. This is one of the very few special civil actions where you will find the breach. I will discuss that much later on. Okay, I hope it's clear. I'm just going into a clear distinction of the two. Now, there is also what we call personal in real action. Now, don't be misled. Take note. I'm now referring to Rule 4. If you will look at the syllabus, some of you would say, oh, wala namang Rule 4. Diba? Look at the syllabus, class. Some of you will say, oh, wala namang Rule 4. Hang on, class. In the syllabus, you will find there the kinds of action which is real and personal. Let's make a distinction. It is a real action for purposes of venue under Rule 4 when it involves title to possession or interest over real property. And in that rule, it specifically provides that if it is an ejectment case, it is in the MTC or Metropolitan Trial Court, Municipal Trial Court, where the property is located. I would like to be very clear with that. Now, that is what a real action. So here, the venue is dictated by the place where the property is located. I'll repeat. Considering that it involves title to possession or interest over real property, the venue of the action is dictated by the place where the property is located. Although Section 1 further clearly states if it involves ejectment, it will be in the MTC. It does not say jurisdiction. It only follows what is already in the law. It says MTC for ejectment cases in the place where the property is located. Clear? Now, you also have what? Personal actions. So an example of personal action will be specific performance, rescission of contract, recovery of sum of money. These are examples of personal action. And here, personal actions, again, in relation to Rule 4 on venue of action, the venue of the action for a personal action is dictated by the place of residence of the plaintiff or principal plaintiffs or the defendant or principal defendants at whose option? At the option of the plaintiff. So the determination of where to file is with the plaintiff, okay, at the option of the plaintiff. But it also happens that the plaintiff is here in the Philippines, but the defendant does not reside in the Philippines. If it involves the personal status of the plaintiff, I will repeat, if it involves the personal status of the plaintiff, it will be instituted in the place where the plaintiff resides. Of course, the defendant has no residence in the Philippines. Second, take note, second, if the defendant is not a resident of the Philippines, but he has a property in the Philippines, which is subject of the controversy, the action shall be instituted in the place where the property is located. Because the subject of the controversy is the property, and it is the res, okay, R-E-S. Now, having said that, you would know where to institute the action. Now, again, as a final word on this, on Rule 4, I would like you to remember, though, that parties to an action can agree in writing. It's possible that there is a law that provides for a venue, like in co-warranto, like in adoption cases. But of course, now it's administrative. There is a law that provides for a venue. For example, in Rule 24. Wherein it's deposition before action, it's in the place where the prospective adverse party or defendant resides, where the deposition is to be conducted. You see that? There may be laws or rule that will provide for a venue. In that case, that will prevail. That will prevail. However, it is also possible that the parties can, before the action is instituted, or maybe at the time when the relationship is still very much harmonious, at the time of the execution of the contract, they could stipulate on the venue of the action. But again, remember two things. If you will find there words of exclusivity, exclusively only waiving all other venues, what is only in the contract will be the place, where the action is to be instituted. Are we clear? However, if you read the contract and the contract does not does not provide for words of exclusivity, meaning the parties agree it may institute the action in Quezon City. What is in the contract is only in addition to what is in the rule. I will repeat. So if the property is located in Cebu, they stipulated, meaning it's a lease contract in Cebu, they stipulated the properties in Cebu, they stipulated that the action will be instituted in Quezon City, okay? And there are no words of exclusivity. Quezon City is just in addition to what the rule provides. If there are words of exclusivity and it says the action shall be instituted only in Manila, though the property is located in Cebu, it will only be in Manila. Are we clear? So I hope that's clear. Remember those words of exclusivity, and in the absence of those words of exclusivity, what is in the rule, what is stipulated, will only be in addition to what is in the rule. Are we clear? Now, I will leave that matter completely. I will now proceed to Rule 3. I hope you're still with me, class. I hope you're still with me. I'll try to walk you through. Just be very patient. Some of you at this point may be fatigued already. Okay? Just listen to me. Pakinggan nyo lang ako. Sana naman dito sa aking sinasabi ngayon ay may lalabas. Okay? Sana may lalabas. So just be patient and I will walk you through with all of this and hopefully this will help. Okay, now let me now proceed to discuss a necessary party or an indispensable party. Take note of that. Huh? A necessary party should be pleaded in order to have what? Should be pleaded in order to have a complete determination. The absence of a necessary party, will not render any judgment null and void. Because the necessary party is only there in order to complete the determination of the court. Are we clear? However, kindly take note, if the court, according to Section 9 of Rule 3, issues an order, there being a declaration that there are necessary parties, and that the court requires you to plead a necessary party, you're the plaintiff, and you being the plaintiff, you fail to plead a necessary party despite the order of the court. Should the court render a judgment at some future time, that will amount to a waiver of whatever claim you will have against that necessary party, who you failed to plead despite the order of the court. But if there is no order of the court to plead a necessary party, you could still proceed to claim at some future time. Okay? Now, as differentiated from an indispensable party. An indispensable party, kindly take note, must be impleaded to have a final determination, such that if you fail to implead an indispensable party, any judgment that will be rendered by the court is null and void. I repeat, the failure to implead an indispensable party will render any judgment of the court null and void. And if that judgment became final and executory, for as long as it's filed within the proper period, let's say there is probably the failure to implead the indispensable party would have been because of extrinsic fraud or lack of jurisdiction, then you could file an annulment of judgment. There are so many jurisprudence on that. Take note. Now, kindly take note that the policy of the Supreme Court today, the policy of the Supreme Court today is before dismissing a case. Because, class, remember, it's useless to proceed if you fail to plead an indispensable party, correct? Why? Because at the end of the tunnel, or at the end of the day, the judgment will be null and void. So if the court, for example, is alerted that an indispensable party is not impleaded, please bear in mind that the court should not immediately dismiss the case. Take note, that's the policy of the rule today, and policy of the Supreme Court in its decision. The court will not dismiss it, but the judge who has been alerted of the failure to implead an indispensable party should issue an order requiring the plaintiff or the party to implead the non-impleaded indispensable party. Okay? To implead the non-impleaded indispensable party. Failing to do so, it's only at the time that the court can dismiss the case. I will repeat, it's only at the time that the court can dismiss the case. Now, I hope you're still with me. Class, I will now discuss joinder of causes of action in relation to joinder of parties. Okay, baka akala nyo, nakalimutan ko na. Sabi mo, sir, meron ako doon sa syllabus na yun. Okay? We will discuss that together. Okay? So the pertinent provision when it comes to joinder of causes of action is Rule 2, Section 5. Are we clear? Rule 2, Section 5, when we talk of joinder of causes of action. Please bear this in mind. If it is one plaintiff party against another party, he has a claim, whether in the alternative or otherwise, he could have as many causes of action as he has. I will repeat, he could have as many causes of action as he has. If there is one plaintiff and there is one defendant. Kindly take note. Now, let me ask you this question. So what if there are multiple parties, there are multiple plaintiffs and multiple defendants? Listen, Section 6 of Rule 3 will apply or must apply. Rule 3, Section 6 will apply. What is that? Permissive joinder of parties. And for that reason, class, if there are multiple plaintiffs on one side or multiple defendants in one side, it must be shown that these parties can be brought together in one action if there is a common fact or law. Okay? Or there is what? That the claim arises from the same transaction, I will repeat, from the same transaction or series of transactions, jointly, severally, or in the alternative. So, ganun yun. So, ganun pala, class, pag yung multiple parties. Yes, hindi mo pwedeng pagsama-samahin yan kung walang relasyon yan. Maguguluhan ang court. Next. I'm now still on joinder of cause of action. Kinarve out ko lang, class, yung joinder of parties. Permissive joinder of parties. Because that is a rule in joinder of cause of action. Okay? And there is also what you call the totality rule. Meaning, the jurisdiction or the filing will be determined by the sum of all claims. Meaning, the court that will handle the case or when it will be filed will be determined by the sum of all of the claims. So if the claims would exceed the totality of the claims, whether there are 3, 4, 5 causes of action, exceeds 2 million, it will be with the RTC. You could join them together. Like for example, there are 3 promissory notes. One would fall with 1.5 million, the other is 3 million, the other is 5 million. Well, you could opt to file the 1.5 million in the MTC and go through what? Summary procedure, because it's 1.5 million, not 1 million and below. Do you get me? You could do it there. You could also file the 3 million in the RTC and the 5 million separately, subject of separate promissory notes separately. Do you follow? But you could bring them all together, a total, and then you file it with the RTC. Totality rule. The next one, class, that I would like you to remember is that you cannot join those covered by special rules. You cannot join something which is habeas corpus and certiorari. You get me? You cannot join settlement of estate and certiorari. You cannot do settlement of estate and rescission of contract. You can, because these are covered by special rules. And the last one here is what? You could join as many causes of action, class, for as long as they are all ordinary civil actions. But for as long as the rule, one falls with the RTC, even if the rest are with the MTC, the rest will follow. For sums of money, it's very easy, but some are get to be confused if one is a personal action and one is a real action. There's still no problem for as long as one. So long as it's ordinary civil action, it follows the RTC. And venue lies therein. I'm done with joinder of cause of action. I'm done with permissive joinder of parties. Now, in class yung compulsory, say indispensable parties. Yun, yung sinasabi ko. I already discussed that. Now, let us now proceed, class. Okay? Let us now proceed to a class suit. Okay? Kindly take note. Remember that a class suit is that the parties are so numerous. That's impracticable to bring them all in court. So at this point, there should be a representative of the class. And kindly take note that it will only be considered as a class suit if there is a common or general interest. Kindly take note. For example, you're talking of an access road. No one has varying interest except that I would want to be able to pass through the access road. Then what? That is a class suit. Because of a common or general interest. Or I would like to claim about intergenerational interest, like in the case of Oposa versus Factora. Well, we have to protect the environment and every one of us are affected. Even now who are present and those who are yet on board, that is a class suit. Now, sasabihin mo, sir, hang on. Hindi ba yan yung part of environmental rules? Yun nga pinagsimulan niya. That is a class suit. Okay, now, let us now proceed. Class suit. if you have difficulty, and I would like to remind you this, if in the bar exams you have difficulty, this problem is presented. Sir, ang hirap identify common or general interest. This is my clue. This is my suggestion to you. I would want you to look into the diversity of interest. So if there are varying diverse interests among the claimants, that cannot be a class, that can be a common or general interest, because there should be a separate outcome or judgment for everyone. So if it's a bus collision, it cannot be a class suit of all those who were injured, because all of them have different conditions in life, status in life, age, opportunity to earn, all of those, and life expectancy. That would that. It cannot be a class suit. And my final word on class suit would be this. What is this? Adequacy of representation. So those who claim to represent the class should adequately represent the class. For example, it cannot be that you're only 20, you claim to represent 500. Okay? In the case of Banda versus Armita. Early on, there were 30, and then immediately after some time, it was reduced to 20 who were claimants. They claimed to represent the class, but the rest have no interest at all. So the Supreme Court said, following the case of Islamic Dawa, there is no adequacy of representation. And when we talk of adequacy of representation, they represent the class in terms of the percentage of the representative to the class of persons that they claim to allegedly represent. So that is a class suit. And can you take note, do not be misled, that this class suit is only for a class of plaintiffs. It also represents a class of defendants. There could be a class of defendants. Please remember that. Now, I will now proceed to my next discussion point. I will now discuss death of a party. You're still with me? Okay, you're still with me? Death of the party, Rule 3, Section 16. Okay, Rule 3, Section 16. Sir, what about Rule 3, Section 16? Class, as I said a number of times, that if a party, it's possible that a party to an action dies. Tama ba yun? Yes, class. A party to an action dies. And it could be a plaintiff or it could be a defendant. So if you're confronted with that bar exam question, pagbasa mo, may patay. May namatay na party, plaintiff or defendant. These are the things that you will have to ask yourself. Number one, what is the nature of the action? Well, by the nature of the action, will the action survive despite the death of the party? If your answer is yes, then Section 16 will apply. And number two, any party dies. Take note, any party dies. It could be the plaintiff, it could be the defendant, and the next thing that you will have to remember is that the action survives. If it does not survive, for example, there is a claim for support and the one claiming for support dies, wala na. It's a nullity of marriage, yung asawa, patay na, wala na. Do you get me? But if it's a rescission of contract, quieting of title, rescission of contract, specific performance, and all those other cases, class, it will survive. Action reivindicatoria, it will survive. Okay. Now, the next question is, if the action survives, what happens to the case? The case will continue. But before it continues, remember this, there is a need to effect or to complete a substitution. I repeat, to complete a substitution under Rule 3, Section 16. And before I proceed, okay, in accordance with the case of Napere versus Barbarona, anong sinasabi dito? That substitution is to satisfy the requirement of due process. I repeat, substitution is to satisfy the requirement of due process. Take note, substitution is not to satisfy jurisdiction. Therefore, substitution is not jurisdictional. Substitution is to satisfy the requirement of due process. Are we clear? Okay. Now, please follow this. The requirement of substitution, there will be complete substitution, to be more accurate, if the party, through counsel, the counsel of the deceased party, complies with its requirements under the rules. And then the court also complies with its requirements under the rules. Only then will there be a successful substitution. Are we clear? Now, let me be very brief about this. So in a situation like that, the party whose client dies has a duty. The lawyer of the party who dies will have to inform the court within 30 days from the fact thereof. I repeat, should inform the court within 30 days from, when I say the fact thereof, from the fact of death. Not from knowledge of death, but from the fact thereof. Di lang mag-give example, Preweek na to, nagbigay na ako doon, noon eh. Okay? From the fact thereof. That's the duty of the lawyer. And together with the notice of the fact of death, of course, he will have to attach a proof of such death, a certificate of death for that matter. He will also have to state there who the legal representative or representatives of the deceased will be. And who could be who? Who could be? The representatives could be heir or heirs, executor, or administrator. Liwanag ba, class? Now, if the lawyer complies with his duty, this is just one requirement satisfied. One requirement being satisfied. Sir, is there already substitution? Not yet. Because it is the duty of the court to require the legal representative named by the lawyer in the notice to what? To appear in court and to order substitution. I repeat, to issue a notice to appear and order substitution. You get me? Once that is complied with by the court, there is substitution. Now, you will tell me, sir, minsan hindi naman nagagawa. Yes. If, for example, there is no substitution and there is no successful substitution, therefore there is no representative of the deceased, any judgment is null and void. Are we clear? Because this is a requirement of due process. Now, but class, there are so many cases. Baka meron sa inyo, sir, hindi naman lahat ganyan eh. Okay, class, there are certain instances wherein the rules, the procedure was not complied with. The lawyer did not do what he has to do. The court failed to comply with what is incumbent upon it under the rules, Rule 3, Section 16. But a representative of the deceased, maybe an heir, maybe a relative, maybe a new counsel, comes into the picture and what? Actively participates in the proceedings. Now, assuming that the court recognizes his participation, his entry of appearance, then the court eventually renders a judgment. The judgment is what? Valid. Sir, hindi naman sinunod yung procedure. The judgment is valid. Why? Because the requirement of due process was satisfied. We clear? That's death of a party. But hang on, class. Hang on, hindi lang naman ganun yun. Death of a party. Death can also happen when? In Section 20. You have to be very careful with this. Baka akala nyo, kaya hindi ko iwanan. Baka mamibigyan kayo ng ganitong facts. Section 20 of Rule 3, there is death also. When the defendant dies, remember that Section 20 is a provision with a very narrow application. I will repeat. Section 20 is a provision which has a very narrow application. Are we clear? Here in Section 20, it is the defendant who dies. That's a requirement. Okay? In Section 20, the defendant dies. And number two, what's the nature of the action? It is a claim for money. Okay? Contractual money claim. Okay? A claim for money, whether express or implied. So listen, class, huh? Let's paint a little scenario here. Okay, in such a case, it is the defendant who dies. What happens to the case? Will there be substitution? No. As I told you, this is Section 20, is a provision that has a very narrow application. There will be no substitution. The case will proceed, kindly take note, against the estate of the deceased. Therefore, don't get me wrong, sir, hindi tutuloy na. No. The estate will now replace the deceased party. So, if it is Juan de la Cruz, estate of Juan de la Cruz. Sir, not substitution, not substitution. But the case will continue. It will not be dismissed. You don't need to claim to the estate. For now, you will have to complete the case. So it will now be, the case will now be against the estate of Juan de la Cruz. If originally the defendant is Juan de la Cruz, estate of Juan de la Cruz, and it will proceed until judgment. Liwanag ba, class? That is how it is. Now, look at this. Sir, paano if it is the plaintiff who dies? Sum of money is the plaintiff who dies, who is not the defendant. Because, class, as I said, Section 20 is a very, very narrow application. Section 20 is a very narrow application. If it is the plaintiff who dies, and it's a sum of money claim, it is not Section 20 that will apply. It should be a rule. It should be Rule 3, Section 16. It's Section 16 that will apply. Right? Remember that. Okay. Now, I will proceed with another example of a death. Okay? Section 17, there's death of Rule 3. Sir, ano yun? Class, a public officer, under the provision, a public officer resigns, dies, or ceases to hold office. Eh, di nandun, may patay. What happens? There will be what? Substitution. But before there is substitution, by who? The successor of that public officer who dies. If it's a cabinet secretary. If it's a secretary, then the new appointed secretary will have to substitute him. But before that happens, the court will have to give that successor an opportunity to be heard. As I said, this is a requirement of due process. Do you intend to adopt the act of your predecessor, or you threaten to adopt the act of your predecessor? In that case, he will be given an opportunity to voice his side. There is an opportunity to be heard. He'll be given 30 days. Okay. Only then will substitution take place. I think that's covered. Okay. Now, let us now look at my last item for Rule 3, based on your syllabus. And what is that? Transfer of interest. For those of you who were with us during the question and answer in civil procedure just a few weeks ago, makikita nyo in class na a few weeks ago that I discussed this transfer of interest. So class, transfer of interest is another matter that could lead to, or another situation that could lead to what? Substitution. But let me illustrate this for you. I hope that those who were there in the question and answer will still remember it. Let's say A sued B. Do you get me? A sued B. While the action was pending, B transferred it to C. Do you get me? B, the defendant, transferred it to C, his interest. You get me? Now, what happens? The question is, can the case continue against B? The action of A continue against B? The answer is yes. Can there be a valid judgment? The answer is yes. But will this judgment against B affect C? The answer is yes. Because he acquired it knowing that there is an action. No, sir, he didn't know that there was an action, but still, that is the subject of the controversy. So he has to be covered by the judgment. Now, it is also possible that A, if he learns of the transfer, can impede who? C. So now B and C will be defendants to an action. And therefore, judgment is valid against the both of them. But can you take note, even if it's B only, the defendant, judgment could bind C. Now, it is also possible that if the court learns of it and the plaintiff calls attention of the court can order substitution. C will replace B. And therefore, there will be a new defendant, and that's where substitution comes in. Then the court can proceed to render a judgment. That's transfer of interest, Section 19. Okay? We will now proceed to what? To pleadings. Okay, let us now proceed to pleadings. We will start with Rule 6. Okay, class? Hindi ko na class ito. Tandaan nyo, hindi ko to iisa-isa. Complaint, and then, no, hindi. I will highlight those topics which I feel are significant. Okay, now, the first thing I would like you to touch on would be affirmative defenses. As you know, there is a complaint that lays the cause of action or claim, and under the present rules in relation to Rule 11, the defendant can file an answer. Okay? He has to file an answer within a period of 30 days. Sir, can he extend? He's entitled to, he can apply for a one-time extension for good or meritorious reasons. For good and meritorious reasons, he could ask for a single extension of 30 days. Okay. Now, I would like to be very clear. In relation to Rule 7, Section 6, sir, lumalayo ka, hindi, class. Rule 7, Section 6, whether it be a complaint or whether it be an answer, okay, the requirement is any pleading that lays a claim or a defense shall, together with the pleading, whether it be a complaint or whether it be an answer, attach a judicial affidavit of all its witnesses. Judicial affidavit, summary of the witness statements, attach documentary and object evidence. And that is also the same requirement for an answer or any pleading for that matter that lays a claim or a defense. Okay, class, are you with me? Now, I will try to tie down, I will try to tie down tie together provisions in my discussion of affirmative defenses. Take note of this. Huh? Now, let's look at this. Let us say that the defendant files an answer and the answer raises affirmative defenses. Kindly take note. Please bear in mind that today, once a defendant receives the complaint, summons and the complaint, he has to file an answer. That's the general rule. Sir, why? Because a motion to dismiss under Rule 15, Section 12 is a prohibited pleading. Generally a prohibited pleading. Listen, except if the grounds are subject matter jurisdiction, litis pendentia, res judicata, and prescription. Are we clear? Those grounds, subject matter jurisdiction, litis pendentia, res judicata, and prescription. Are we clear? Ganun lang yun. Okay, now, but he could file an answer. He could file a motion to dismiss based on those limited grounds, and he could file an answer. Now, class, please remember this. An answer can raise affirmative defenses, correct? And the affirmative defenses, class, are provided for in Rule 6, Section 5B. There are 2 paragraphs, okay? And kindly take note that an affirmative defense is raised, though the defendant hypothetically admits the material allegations of the complaint. So parang inamin niya, okay, may utang nga ako, pero bayad na yan. Okay? That's an affirmative defense. The defendant says, okay, may utang nga ako, pero winib mo na yan because it's your birthday. Right? Oh, still on Rule 6, Section 5B, first paragraph. Oh, sabi mo, may utang ako? Yes, pero prescribed na 15 years na, you're still trying to recover from it. You get me? Those are what you call affirmative defenses. I just want to be very clear. Now, having said that, remember, class, that the grounds for a motion to dismiss, kasi nga ngayon limited na lamang sa 4 ang grounds for motion to dismiss, are now affirmative defenses. If you will note Rule 6, Section 5B, first paragraph and second paragraph. These are affirmative defenses. Okay? And class, additionally, Rule 8, look at this. Rule 8, Section 12 tells you that those previously grounds for a motion to dismiss are now grounds for what? Affirmative defenses. Let me illustrate this for you. Okay, let me illustrate this for you. Class, let me illustrate this for you. First, ano ba yung ground na yan? Na affirmative defense na ngayon? Lack of jurisdiction over the person of the defendant. Okay? The venue is improperly laid. Take note, the venue is improperly laid. Ano ba yan? The plaintiff has no legal capacity. The pleading asserting the claim states no cause of action. I repeat, the pleading asserting the claim states no cause of action. This is different. I would like to put a note, a very big note. This is different from lack or absence of cause of action. Because, class, you cannot raise that as an affirmative defense. Lack or absence of cause of action goes to the sufficiency of the evidence presented. And you're trying to tell the court that there's no prima facie case despite presentation of evidence. At that point in time, you could find the murder evidence. Hindi yun. Okay? When you say the pleading asserting the claim states no cause of action, yung complaint pag binasa mo, walang cause of action, walang breach violation. Right? And finally, non-compliance that a condition precedent for filing of a complaint has not been complied with. Like, for example, non-referral to barangay conciliation, there is no mediation if it involves or pursuit to achieve an amicable settlement if it involves a dispute between members of the same family. So kindly take note. But the thing now, class, is under Rule 8, Section 12, in relation to Rule 6, Section 5, an affirmative defense, if raised in an answer, will have to be resolved by the court. Okay? Hindi na kailangan na, Your Honor, motion to resolve affirmative defenses or preliminary hearing of the affirmative defenses. No more, that's a prohibited pleading. The duty of the court is to resolve it within 30 calendar days from the filing of an answer. Take note, it's also possible, based on the grounds on Rule 6, Section 5B, first paragraph, like prescription, estoppel, payment, waiver, and other modes to extinguish obligation. Class, the court can conduct a summary hearing. But kindly take note that it is the duty of the court to resolve it, the affirmative defenses, within what? 30 days from the termination of the summary. Listen to my next discussion point. Take note. Any affirmative defense, any action of the court on the affirmative defense, which denies the affirmative defense, take note, which denies the affirmative defense is not subject to a motion for reconsideration, certiorari, prohibition, or mandamus. But this may be matters raised on appeal later. So class, hindi pwede. Pag dinay affirmative defenses po, you cannot go up on Rule 65. You cannot even file a motion for reconsideration. Kindly take note. But you will have to take note of this in relation to Rule 15, Section 12. Even if it is granted, you can file a motion for reconsideration. Sir, wala naman dito. It's not provided for in Rule 8, Section 12, right? Because class, it's found in Rule 15, Section 12 that says any action on an affirmative defense cannot be subject of a motion for reconsideration. I repeat, any action on affirmative defense cannot be subject of a motion for reconsideration. Therefore, if the affirmative defense is denied, no motion for reconsideration is required, allowed. Even a certiorari, prohibition, mandamus is not allowed. Certiorari, prohibition, mandamus not allowed. Later, those could be raised in your appeal after judgment. Now, what if, ngayon tatanungin mo ko, sir, what if, okay, sasabihin mo sa akin, sir, what if the affirmative defense is granted? Listen, class, listen to this. If the affirmative defense is granted, please bear this in mind. If the affirmative defense is granted, you have to watch out whether the dismissal is without prejudice or with prejudice. I'll give an example. Lack of subject matter jurisdiction, the dismissal, sabi ng court, okay, affirmative defense din ginamit the motion to this affirmative defense. Dismissed. Okay? So you cannot file. Granted, the affirmative defense, I cannot file an MR, correct? But I'm not convinced the court was wrong. Okay? The court was wrong. It is without, the dismissal is, take note, without prejudice, correct? It's without prejudice. So, is it subject of appeal? No. It could be subject of a certiorari because you cannot appeal a dismissal without prejudice. Okay? Like, for example, improper venue. Dismissed, affirmative defense. I dismissed mali, wrong venue. That's, you could refile, correct? You could refile. So therefore, because you could refile, it is a dismissal without prejudice. What's your remedy? Well, what's your remedy? If it is an affirmative, if it is on improper venue. Okay. Plus, improper venue, kindly take note that in all of this, I would like to be very clear, though I may be misquoted. No? All of the affirmative defenses cannot be elevated on a certiorari. Okay? Pero class, pag denial yan. Pero pag granted yan, ginrant yung improper venue. Sabi dismissed. Why you cannot file a motion for reconsideration? Because that's an action on the affirmative defense. You could opt to refile it, correct? But if you're not convinced with the court in denying in granting the improper venue, in dismissing your case, you could elevate it on a 65. That's not subject of an appeal. Do you get me? The grant of an affirmative defense, kindly take note, you can refer to Rule 15, last section. Take note, Rule 15, last section. That which could be a dismissal with prejudice. Okay, a dismissal with prejudice can be subject of an appeal. Examples of dismissal that's subject with prejudice that can be subject of an appeal. Class is prior judgment. Res judicata. Prescription. That cannot be subject of refiling. If you think the court was wrong in saying that your action is prescribed, you could appeal. But again, you cannot file an MR to the grant of the affirmative defense. Sir, ang gulo, bakit? Kasi class Rule 15, Section 12 says it's a prohibited pleading to file any MR on any action of the court on an affirmative defense. So be very careful with that. That's why I'm walking you through this. Take note, I will repeat, of Rule 7, Rule 6, Section 5B, in relation to Rule 8, Section 12, and in relation to Rule 15, Section 15. Okay? Para hindi tayo maubusan ng oras, I would want you to take note of that. Huh? Now, having discussed affirmative defenses in relation to motion to dismiss and remedies available to you, I will now touch on a reply. Okay? I'm still on pleadings. I will now touch on reply. Sir, what do you have to remember? Do you want us to remember about reply? Please bear in mind that all new matters raised in the answer are deemed controverted. The plaintiff, if the plaintiff wishes to interpose any claim arising out of those matters alleged, such must be set forth in an amended or supplemental complaint. So take note, if there are new matters raised in an answer and you want to face this, you cannot file a reply if you are the plaintiff. Okay? If you receive an answer, oh, these are new matters raised. Payment, waiver, okay, these are new matters, prescription. But you will have to amend your complaint or file a supplemental complaint. Take note. However, you can only file a reply in a very limited instance. You can only file a reply if the answer raises an affirmative defense. So in its affirmative defense, in the affirmative defense in an action, affirmative defense in an answer, to be very specific, in an affirmative defense in an answer, he raises an actionable document. So doon ka lang pwede mag-reply. Sir, sino mag-reply? The plaintiff. I will repeat to be very clear. So again, the complaint files an answer. A complaint, not the complainant files an answer. There's a complaint. There's an answer to be filed within 30 days. Correct? 30 days. Now, as a rule, once an answer has been filed, issue subject, pre-trial yan. You get me? Pre-trial yan. The only instance that the plaintiff here, the complainant, could file a reply, the new matters raised in the answer are deemed as controverted. The only instance that the plaintiff can file a reply is when this answer raises an actionable document. In raising his affirmative defense, he may have presented or attached an actionable document, then the plaintiff will have to file a reply. Are we clear? To specifically deny this. To specifically deny this. Now, let me now touch on, okay, a third-party complaint. Okay? But before I touch on the third-party complaint, kasi para nas-touch ko na yung specific denial. Okay, specific denial under oath. Let me now just touch it one more time for the last time. Sabi ko, class, the only instance where the plaintiff could be allowed to file a reply is when an answer alleges or uses as a defense an actionable document. So the plaintiff can file a reply to meet this, specifically deny this under oath. You get me? Now, let me now touch on actionable documents under Rule 8. Para isahan na lang. Okay? As a general rule, class, today, a complaint must lay a claim, of course, a cause of action. But the requirement now of Rule 8, Section 1, that together with the ultimate facts raising the claim, you will have to include evidence. Okay? You have to include evidence. But that did not change the concept of actionable documents. So if your complaint or your claim, the basis of your complaint is an actionable document like a contract of lease, like a contract for construction of a building, these are examples of what? Actionable document. So if these are attached to the complaint, when the defendant receives the complaint, take note, when the defendant receives the complaint, this defendant has to specifically deny the actionable document attached to the complaint. And how does he specifically deny under oath? Under oath, he will have to specifically deny, saying that no, that document doesn't exist. Class, that would depend on the factual antecedents of the case. Baka naman sabihin nyo, sabi ni sir, hindi totoo. Hindi. That this is just an example. Okay? You will have to attack it. Like, for example, if it does not really exist, specifically deny it under oath. But if it exists, why would you deny it? That's telling a lie. Do you follow? So if, for example, the complaint has with it an actionable document, has with it an actionable document as a basis of this claim, the defendant can what? Specifically deny it under oath. We could deny it under oath. And when we say under oath, it could be in a verification or in a separate affidavit. Now, failure of the defendant to specifically deny the actionable document attached to the complaint, that would amount to an admission. Take note, ganun ka-importante yan. And that would amount to a judicial admission. And why is that so important? Because it's a judicial admission according to Rule 129, Section 4, it requires no proof. Okay. You don't need to prove it in the course of the proceedings. You don't need to authenticate that document because he's actually admitted it by his failure to specifically deny it under oath. If it's a private document, you don't need to present a witness to say, I've seen him sign the document, or that I'm familiar with the signature of the person, and that the handwriting is genuine by comparison of the witness. Wala na class doon. Kasi because of your failure to specifically deny it under oath. I hope that I have explained this. But the requirement of a specific denial under oath is not required. Okay, the specific denial under oath on the part of the defendant is not required if the defendant is not a party to the document. How can you deny something that you do not know, that you are not a participant to? Okay. Or number two, there is a request for inspection. Okay. There is a request. Okay. There is a request for inspection. Okay. To be specific, not only a request, there is a court's order for inspection to allow the inspection of the original, but the party refuses to comply. Then the defendant did not specifically deny it. Okay. Now, I'm done with that. I will now proceed to a third party complaint. Take note that. You're still with me. We are now on a third party complaint. Now, the thing with the third party complaint, class, is it requires leave of court. So class, normally kasi yan, complaint, the complainant sues the defendant. Yun lang yun. Summons are served, the court departs jurisdiction of the person to the defendant. But there are times the defendant would say, but Your Honor, Pedro will have to contribute, will have to indemnify me. Because it was not I who caused the damage to this plaintiff. You get me? So he will say, tell the court, Your Honor, I will have to implead Pedro because he has to contribute. He has to indemnify me if I'm held liable. Or he should be subrogated. Or what? Subrogated or any other relief that would be necessary. So kindly take note, that's the concept of third party complaint. Again, that is what? That requires leave of court. Okay, the mere fact that you allege a third party complaint does not mean that it is admitted. You will have to convince the court that it is not, the third party complaint is not extraneous to the issue of the case. You will have to convince the court that it is not subject of a new or separate controversy. Otherwise, your motion to admit the third party complaint will be denied by the court. Not related, extraneous. This is a new matter, not connected with the case. Or even if the court initially admits it, there is one. The party defendant cannot be located after 30 calendar days from the grant of leave. So from the grant of leave, the court says, okay, it's related to the case, but we can find the third party defendant. You're given 30 days. Failing to do so, it will be denied. Okay, now, kindly take note that the denial of the third party complaint does not bar any claim against the third party defendant. Okay? The court shall require the defendant to institute a separate action. The court could say, okay, you just file a separate action because this is not related. This is extraneous. This is a different controversy. Or, worse, the court initially admitted it and the court says, initially admitted it, but you can't locate the third party defendant. Okay. Just file a separate action. Now, if for one reason the court issues an order without making such a statement, file a separate action, will that be a bar in that? Will that be a bar or will that prevent you from filing an action? No, class. It will not prevent you. Okay? Now, let us now proceed with rule. We will now proceed with rule 7. Okay? Parts of pleadings. Now, class, I would want you to give special attention to this. I would want you to give special attention to this because I'll try to walk you through signature, verification, certification. All right. I believe these are material matters that you have to be refreshed before you take the bar on the last Sunday. Okay. Take note of it. Now, class, under the rules today, okay, take note, under the rules today, it is the duty of every lawyer to conduct an inquiry reasonable under the circumstances. Because the very moment he signs, he will tell the court, Your Honor, this is based on my knowledge, information, and belief that I formed after inquiry reasonable under the circumstances. And together with that signature, you know what I'm telling the court, Your Honor, that the filing of the action and that my signing is not for an improper cause, okay, or for an improper purpose. This is not to harass a party. This is not to delay a cause or to increase the cost of litigation. Yun ang sinasabi mo, class, when I sign. when every lawyer signs. And you also tell the court, Your Honor, the claim defenses or other contentions are warranted by law and jurisprudence. So you could be the claimant, you could be the defendant, and you will tell the court, Your Honor, this is warranted. My claim of defense is warranted by law and jurisprudence. And if I raise arguments that are not supported by law and jurisprudence, plus it is non-frivolous. I'm practically telling the court, Your Honor, this is non-frivolous. This is not frivolous. This is intended to reverse probably a jurisprudence, okay, or to modify an existing jurisprudence. The next, kindly take note that the factual contentions there, by signing, the lawyer also tells the court, Your Honor, no, the factual contentions here are supported by evidence. That if it is not so supported by evidence at the time of the filing of the complaint, or the time of the filing of the initiatory pleading, by the availment of the modes of discovery class, there I will be able to establish evidentiary support to my claims. And the next is, if I deny, for example, I'm the defendant's lawyer and I sign, that the denials in the answer or in the pleading are warranted, are supported by evidence. So it's not suppositions. These are not speculations. These are not matters I raise just from thin air. Meaning, if I deny, there is evidence to support it. And if so specifically denied, are reasonably based on belief or lack of information. So class, please bear that in mind. The next item here, I'm still on the signature of a lawyer, class. I would want you to remember, class, that the signature, if you fail to comply with those attestations that I've mentioned, upon motion of a party or motu proprio, after notice and hearing, the court can impose sanctions. Okay, sabi na niloloko mo ako eh. Your allegations are false. It's not supported by evidence. The court can, upon motion of a party or motu proprio one, impose the appropriate sanction. The appropriate sanction could be a fine, a monetary sanction. It could be a non-monetary sanction. Okay? And if, can you take note, if the court sanctions a lawyer who is jointly and severally liable with a law firm, yan ang rule ngayon. The attorney, the partner, the employee of the law firm is jointly and severally liable with the law firm. They cannot pass that on to the client. So these are monetary sanctions, but there could also be non-monetary sanctions. Now, kindly take note also, aside from the court imposing a sanction on the lawyer and the party, it's possible that the court is allowed to refer the matter to the appropriate office for disciplinary action against attorney, lawyer, and the law firm, even the partner. Okay, please bear that in mind. So I'm done with this, the signature of a lawyer. I will now proceed with the verification. Please bear in mind, class, that the verification is to be signed by the verification is to be signed by a party. Okay? Whether it be a natural person or a juridical person. If the natural person is not available, a special power of attorney should be given to the person who is to sign. If it is a juridical person who is a party to the case, who is to execute a verification, it should be supported by a board resolution embodied in a secretary's certificate. But please bear in mind that that's a genuine rule. It should be a party who would sign the verification. Now, a verification is a requirement of form, and therefore it can be subject of an amendment. Take note. It's a matter of form, and therefore it can be subject of an amendment. This is just a reminder for you, class, that but class, don't ignore it, because there are some provisions under the rules that if in the absence of a verification, like for example, an absence of a verification in a petition for review under Rule 42, an absence of a verification under Rule 43, by express provision of the rules, an absence of a verification under Rule 45, or that is appealed by certiorari, or under Rule 65, certiorari provision of the may result to a dismissal of the petition. So take note, it's not that you can completely ignore it. Jurisprudence has been consistent saying it's a matter of form. Okay, it's a matter of form. But the thing, class, is there are specific rules that says that if you fail to comply with the verification, it will be dismissed. The case will be dismissed. And by the time you can correct it, probably the decision is final executory. So you have to be very careful. Now, to proceed further, class, please bear in mind, okay? Please bear in mind that the verification will state that this is what? that allegations in the pleadings are true and correct, based on his personal knowledge. Or probably if he's the custodian of the documents, he has no personal knowledge, that what? What does it say? Or based on authentic records. So he could make a verification because based on the records available with me, I could tell you that's the truth. Kindly take note, okay? And that the pleading, just like this, when the lawyer signs in the verification of the client or the party, says that this is not to harass, this is not for any proper purpose, this is not to harass, this is not to cause delay or to increase the cost of litigation. Okay? And finally, that the factual contentions therein, just like when the lawyer signs, and this time it's the client who says it, that it is supported by evidence, that it has evidentiary support. That if it is not so available, the evidence at the time, it could be obtained, that evidence could be obtained after availing the votes of the court. Are you there? Now, let us now proceed with certificate against forum shopping. You know, during the question and answer in civil procedure, there was a question on forum shopping. And let me just refresh you somehow. Plus, sometimes students are confused about the concept of forum shopping and the certificate. These are two different things. Class, when you do forum shopping, there are substantially similar parties. Take note. The issues are similar. The reliefs are similar. Class. And you file multiple cases. That is what? Forum shopping. Okay? That's forum shopping. And that is prohibited. If you engage in forum shopping, your cases can be dismissed. That's different. And in fact, class, according to jurisprudence, the true case, if there are substantially similar parties, okay, similar issues, relief, but the prayers are what? Different. Okay, that could be treated as what? That could be treated as splitting cause of action, can be treated as forum shopping. That could also be forum shopping. Let's take note of that. That could also be forum shopping. Now, forum shopping as a concept is prohibited. But again, lawyer parties will have to attest to the fact that he will not engage in such a practice. You don't go back to my certificate. You're telling the court, Your Honor, I will not engage in such practice. That is why, aside from the statement that there are no pending cases involving the same parties, and that if you learn of such a pending case, you will inform the court within 5 days from knowledge thereof. And number 3, that you will inform the court if there are other pending cases involving the parties, you will inform the court of the status thereof. You get me? Yun ang nakalagay sa certificate. Now, these are clear attestations. So, listen, if your attestation is false, you're saying that there are no other cases and there is another case involving the same subject matter, really probably issues involving the same parties, then the court will say, the other party will say, that's false attestation. Or you fail to update the court or to inform the court within 5 days of another case having been filed. That is what? Non-compliance. You could be what? The case will be dismissed without prejudice to what? To the filing of criminal and administrative cases. Criminal cases against the party and administrative cases against the lawyer. You get me? Because that's false. That's false non-compliance. You get me? The other one is willful and deliberate forum shopping. Willful and deliberate forum shopping. If it is evident that the intention is really to forum shop, and that would be clear from the allegations of the pleadings, identical, everything identical, then the court will dismiss both cases summarily. And the dismissal is prejudice. And of course, administrative sanctions could be imposed. Are we clear, class? Are we clear? So there's a difference between false or non-compliance to what? To willful and deliberate. In false and non-compliance, the more recent case will be dismissed with prejudice. In willful and deliberate, both cases will be dismissed. Now, it's a different story if you file an initiatory pleading or a complaint and you fail to attach a certificate against forum shopping. Class, this is different. The case will be dismissed because of the absence of a certificate. It doesn't mean that you are engaged in forum shopping. It will be dismissed, but having been dismissed, what happens? It is without prejudice. Can you refile it? Yes, you could refile it. This time attach a certificate. But again, your case has already been dismissed. And you have to pay filing fees once more. Okay, class? Now, let us now proceed. Let us now proceed with the next discussion. Our next discussion, class, will be, our next discussion will be, I'm done with Rule 8 actually, on actionable documents. So I've discussed that together with Rule 6. I will now proceed with failure to plead. Okay, I will now proceed with failure to plead. Now, the thing here, class, that you have to remember when you talk of failure to plead, that rule, yung rule na yan, class, Rule 9, divided into 3 yan. The first one is all ground defenses or objections not raised in an answer or a motion to dismiss shall be considered waived, except subject matter jurisdiction, litis pendentia, res judicata, and prescription. And this should be connected with Rule 15, Section 12. Okay? Yun lang ang pwedeng grounds for a motion to dismiss. Okay? Now, second, please bear in mind that the counterclaim, a compulsory counterclaim not raised will be barred. Okay? It amounts to a waiver. However, class, you have a remedy if you're the defendant and you fail to raise an answer, you fail to raise an answer, you fail to raise a counterclaim in your answer, a compulsory counterclaim, your remedy is a Rule 11, Section 10. What's that say? Rule 11, Section 10. You could amend it to now incorporate your counterclaim. There be an answer, you have to seek what? You have to seek leave from court. That requires discussion from the court, whether or not they will allow you to amend your answer to incorporate a compulsory counterclaim. Then the third is default. Just a few matters that I would like you to remember about default. Always remember, class, that if you're confronted with a problem of default, okay, but if you're confronted with a problem of default in the bar exams, meaning, slowly, read it carefully. If there is no answer, it does not necessarily mean that the defendant is in default. Okay? But this is what you have to watch out for. If there is no answer, you will have to establish the proof of such failure. I said, well, answer it. But the proof of such failure will only be established if you could show that he received the summons. And when he received the summons. And his receipt of summons will be reflected where? In the return of summons under Rule 14, Section 20. Doon yun, kasi magnanarrate ang sheriff, sasabihin niya, ito ho yun, naserve ko sa kanya, so the period starts to run. You get me? And now, if after the lapse of the period, okay, he did not file an answer, whether personally, or by registered mail, or by accredited courier, you get me? Or even electronically, then he will now be declared in default. So the plaintiff will now file a motion to declare him in default. Okay? Now, let us say that the defendant is declared in default. What is the remedy of the defendant? What is the remedy of the defendant? The defendant who has been placed in default can what? Can file a motion to lift the order of default. I will repeat. He could file a motion to lift the order of default. Okay? On the ground of extrinsic fraud, accident, mistake, or excusable neglect. And it should be what? Under oath. That motion to lift order of default should be under oath, and jurisprudence says, it's not provided for in the rules, that there should be a separate affidavit of merit. Why? Because the thinking of jurisprudence is that the defendant would make up stories that why he wasn't able to file an answer. Right? So that he will assert to the court the truthfulness of his claims on his failure to file an answer, and it should be under oath. I will repeat, there should be a motion to lift order of default under oath on the ground of fraud, extrinsic fraud, accident, mistake, or excusable neglect. Excusable neglect. And according to jurisprudence, there should be a separate affidavit of merit. Now, if a defendant has been placed in default, two things could happen. The court can already render a judgment based on what the pleading may want. I repeat, the court can already render a judgment based on what the pleading may want without presentation of evidence parte. Or number two, which is usually the case, the court may require the plaintiff to present evidence ex parte. You follow? So if he's declared in default, there was no motion to lift order of default, tuloy-tuloy na. Tuloy-tuloy na. That the motion to lift is a remedy, plus if he's declared in default. I would like to be very clear. Not because he did not file an answer. So his failure to file an answer led the court to issue an order of default. You get me? And that order of default must be set aside before you can file an answer. Must be set aside. So you file a motion to lift order of default, as I said, on the ground of fame, fraud, accident, mistake, exclusive, or neglect, under oath, and affidavit of merit. Okay, now, let us say that you did not file a motion to lift order of default. The defendant is now in default. As I said a while ago, the court can only render the judgment based on what the pleading may warrant. Or number two, the court can require the plaintiff to present evidence as party. Considering that the defendant now is declared in default, he will be entitled to notices, okay, of the proceedings. So he would know what's happening to the case. He's entitled to notices, except that class, he cannot participate in the proceedings. Okay, so that is the portion from order of default and the consequences thereof, and how to lift it. Okay? With the remedy for an order of default. But there is also what we call a judgment by default, okay, or a judgment of default. Okay. Now, in such a situation, what are the remedies? You could file what? You could file an appeal. You could file what? You could file a motion for reconsideration. Okay. You could file a motion for reconsideration. Yes. Okay. Or a motion for new trial. You will not file a motion for reconsideration because there's no evidence presented on your side. So you could file a motion for new trial. Okay. Or you could file what? You could file if the judgment is already final and executory, and you didn't know the period, reglementary period had lapsed. So you will file what? A petition for relief from judgment. And you could also file an annulment of judgment at some future time. But there is a special remedy provided for in the case of Lina. If there was grave abuse of discretion amounting to lack or excess of jurisdiction, and you learned of the same, you could file a Rule 65. Certiorari. You could file. So I will repeat that. You could file an appeal. You could file a motion for reconsideration. You could file what? If the judgment is already final executory, a petition for relief from judgment, or an end, or annulment of judgment. But again, as I said, within the period of 60 days, if there is truly grave abuse of discretion amounting to lack or excess of jurisdiction, you could file a certiorari. All of those are provided for in the Lina. All of those are provided for in the Lina case. To summarize, before I leave this matter completely, failure to plead, specifically default, let me summarize. For an order of default, the remedy is a motion to lift order of default on the ground of fraud, accident, mistake, exclusive, or neglect. Under oath, okay, motion to lift or set aside under oath with an affidavit of merit. Okay. What if there is already a judgment by default? Meaning it proceeded, the plaintiff is allowed to present evidence, and there is a judgment by default. The remedies are within the reglementary period, an appeal. Within the reglementary period, a motion for new trial. You know why a motion for new trial? A motion for new trial because there was no presentation of evidence. We are trying to tell the court on your part that there was fraud, extensive fraud, accident, mistake, exclusive, or neglect. So motion for new trial, not a motion for reconsideration. Because a motion for reconsideration is a remedy. I will repeat, a motion for reconsideration is a remedy if there was evidence presented by the party. Because the ground is contrary to law, failure to appreciate evidence, and the award of damages is excessive. So the proper remedy within the reglementary period, again, in terms of judgment by default, appeal, motion for new trial. You get me? You can also file a petition for certiorari if there was grave abuse of discretion amounting to lack or excessive jurisdiction, according to the case of Lina. And then once the judgment is already final and executory, you could avail of a Rule 38, petition for relief from judgment or annulment of judgment if the grounds are ready. Okay, I'll leave that. I think I've driven my point. Now, let me now proceed to my next point. Okay. Oh, before I leave that, partial default. Ito lang, tanongin kayo sa bar. Class, if there is a partial default, and there are, for example, multiple defendants, one plaintiff, three defendants, and only two filed an answer. One didn't file an answer. Can the plaintiff be allowed to present evidence? Ex parte, the answer is no, especially so if they have a common cause of action. So much evidence is presented by the two answering defendant can be taken in favor of the non-answering defendant. And the court will have to proceed, just like in a regular proceeding, to have to present evidence, pre-trial, trial, and then the court will render a judgment, even without the answer of a defendant who didn't file an answer, but he has a common cause of action with the two answering defendants. Okay. Now, I will now proceed to amendment. Plus, amendment, please bear in mind that you amend if for one reason there are facts which are already available at the time of the filing of the pleading sought to be amended, but there was oversight or it was omitted, you file an amendment. Remember that there are two kinds of amendment, generally two kinds of amendment. Amendment as a matter of right, meaning you are entitled to that once as a matter of right before an answer is filed. So before an answer is filed, you can amend both as to form and substance once as a matter of right. However, once an answer is already been filed, meaning issues are joined, the amendment will be left to the discretion of the court. The amendment is left to the substantial amendments. The substantial amendments should be left to the discretion of the court. And please bear in mind, and this will only be allowed by the court, or an application for amendment as a matter of discretion will be refused by the court. I repeat, an amendment as a matter of discretion will be refused by the court if the amendment intends to confer jurisdiction. Meaning the court evidently has no jurisdiction, but he wants to amend the pleading to show to the court now that, Your Honor, you have jurisdiction. That will not be allowed. An amendment of that nature will be refused. Or if the complaint at the onset has no cause of action, that will not be allowed. Amendment is a matter of discretion, or the intention of the amendment is purely to delay the proceedings. Now, there is also another type of amendment which we call a formal amendment. These are just clerical amendments. The court, motu proprio, or any party upon motion could say, Your Honor, mali in chronology, okay, or sequence, the number sequence, mali, or there are clerical errors, wrong spelling. These are what you call formal amendments because they are clerical errors. The court can motu proprio correct it or upon motion of the parties. Now, last 2 points in this class, kindly take note, there is amendment. There is no longer a requirement of what? Amendment to conform with the evidence. Okay, I will repeat. You might be reading an old rule or you might be reading an old provision. There is no amendment to conform with the evidence. This is as simple as this. If what was alleged was 5 million, but if in the course of the trial, by the plaintiff, in the course of the trial, he was able to prove the allegations, 5 million, he was able to prove 8 million, there is no need to amend the pleading to conform with the evidence no more. Because the pleading is deemed amended. I will repeat, the pleading is deemed amended. Why? Because there is evidence to support it, even if it is beyond the claim. Okay? And let me quote for you a portion of the provision on Section 5. It says over there, deemed amended is necessary to cause them to conform. No amendment of such pleading, no amendment of such pleadings deemed amended is necessary to cause them to conform to the evidence. So there is no need of amendment to conform with the evidence. The mere fact that you're able to prove it is enough. Even if there is such a variance between the complaint and that which was proven, that's okay. The judgment will remain to be valid. Okay? Now, a last point will be a supplement. Please bear in mind that the supplement is a bit different from an amendment. In a supplement class, please remember that in a supplement, this information that you want to introduce to the court was not yet available at the time of the filing of the pleading sought to be supplemented. Meaning there are new facts, occurrences, or events that may have taken place after the filing of the pleading sought to be supplemented. For example, I filed a claim for sum of money based on a promissory note, and which was for the amount of which became due, for example, on June 30, June 30 of 2024. I filed the claim for 5 million. And the action has already been filed in the RTC because the claim is 5 million. But later on, please bear in mind, by June 30, there's another promissory note that was unpaid. by the defendant, and it was for an amount of 10 million. I have the following options. I could file a separate case in the RTC for recovery of the amount of 10 million based on separate promissory note. Or I could opt to file a supplemental complaint to incorporate this second promissory note, which only became due on July 30. That's the reason why it was not filed together with the June 30 case, the promissory note which became due and demandable on June 30. It was filed, let us say, on June 15. And later on, the second promissory note was also not paid. It was due on July 30. So in that case, what you will find is a supplemental. Having said that, class, I'm done with this. I will now proceed. A bill of particulars is not included in your coverage. Okay, a bill of particulars is not included. So I will now proceed to Rule 13. I've discussed the periods. I'll just leave that to you. Okay, in my basic review. So please remember those. I will now proceed to Rule 13. Okay, Rule 13 na tayo, class, ha? What do you have to remember about Rule 13? So Rule 13 na tayo, class. Class, this is what we have to remember when it comes to Rule 13. Class, Rule 13 is filing and service. I repeat, filing and service. Now, I don't want you to go to the bar exams without remembering this. The manner of filing, class. Look at this. The manner of filing under Rule 13 are as follows. It could be a personal filing. You bring it in court. You bring it to the court of court. It will be personally received by the court. Filing in court. Second, it could be by registered mail. It could be by registered mail. And kindly take note that the date of mailing is the date of filing. So even if the court will receive it at some later time, if, for example, today is, let's say, September 5, which is the deadline, okay, and I went to the post office to file or to have it mailed or to have it filed by registered mail, it is filed on September 5, even if the court will receive it at some future time. You get me? When we talk of accredited courier, it's the same way. When you talk of accredited courier, it could be Ninja, it could be DHL. And if I go to their offices and will cause my pleading to be filed by accredited courier, then it will be considered filed, let's say September 5. That is the date of my filing, even if the court will receive it probably the next 24 hours. Okay? Now, the next is electronic mail. Okay? It could also be filed by electronic mail. And please bear in mind, okay, that it should be what? It is considered as filed when? On the time or the date of its electronic transmission shall be considered the date of filing. So as you know, under the civil code, 1 day is 24 hours. And therefore, even if I file, for example, at 7 o'clock, I press it, I transmit my pleading, it's filed on time. So the date of electronic transmission is the date of filing. Clear? So filing. But in modes of service, there will be a little bit more. And when you talk of filing, it's a part in relation to the court. When you talk of service, it is, of course, the party in relation to a co-party, or probably a court that rendered the judgment, a quasi-judicial agency that rendered the judgment, and that is subject to question. I will have to serve copies because I will have to file here. Probably that's an appeal. You get me? Because filing could be a lot of ways, a lot of things. It could be an ordinary complaint, it could be an answer, it could be a petition, it could be an appeal. Do you follow? So when you talk of filing, your relationship to the court, with the court, and when you talk of service, to a co-party, to a court that rendered the judgment, or to a quasi-judicial agency. Having said that, class, what are the modes of service? You could do it by personally also. You could do it by registered mail also. You can do it by ordinary mail. This remains, class. This remains personal service. Class, tandaan niyo. Na-retain ang ordinary mail. I repeat, personal service, registered mail, ordinary mail was retained, okay, under the 2019 amendments, and one, accredited courier, ano pa, electronic means, or those which are recognized by international conventions. And this one of this is the Hague Convention, to which the Philippines has acceded to and was made effective in October 2020. Okay, let's just take note of that. Now, just a little bit of discussion on personal service. Just a little bit of discussion on personal service. Class on personal service, you have to watch out that in personal service, it could be served to the defendant himself, to the party himself, to the party or counsel, especially if there is one, a counsel of record. If there's a counsel of record, it will be served to the counsel. If there is none, it will be served to the party. And the requirement is it could be served to his office. It is served in his office, a person in charge thereof, between the times of the period of the office hours, okay? 8 in the morning till 6 in the evening, 8 to 6 in the evening. But it can also be served in the residence of the party or the council. That's still personal service. Kindly take note that under Rule 13. But of course, under Rule 14, personal service is different. I repeat. That's why I had to discuss this. Under Rule 14, under Section 6 of Rule 13, yun ang personal service. Because class Rule 13 is other than summons. But when you talk of Rule 14, I'm referring to 14, personal service is you have to hand it personally to the defendant. I repeat, you have to hand it personally to the defendant. If you hand it to a person other than the defendant, let's say to a person in charge of his office, or a person of reasonable age and discretion residing within, who should be at least 18 years of age, substituted service there. That's why I have to mention it. So if you're confronted, as I've been saying repeatedly, if you're confronted with this question in the bar exams, class, if you're confronted with this question in the bar exams, and it's summons, try to remember 14. Do not mix it with 13. 13 is service, filing, and service other than summons. Okay, class? Now, having said that, class, now on Rule 13, I will repeat now on Rule 13, service, as I mentioned, could be made by electronic means or by facsimile. Kindly take note, class, that for the court to be able, for service to be effected electronically, there must be what? There must be a consent of the party. Okay? There must be consent of the party to such electronic service. But again, class, when you become lawyers, you will note that the Supreme Court is now moving towards a direction of primary electronic means. But now, as you take the bar exams, there must be consent of the parties, and it must be ordered by the court. Okay, now, please bear in mind that it is the duty of the party who has submitted an electronic email or an electronic mail to the court to inform the court of such change of email address within 5 calendar days from the change. Okay? Failure to do so. Okay? Failure to do so. The presumption is that the email address with the court is still the valid email address. And you will have to be notified through that email. So it is the duty of a party to inform the court within 5 days from change of email address or electronic address to inform the court. Otherwise, the presumption is your own email is the valid email. Now, let me now proceed with a few more items. Class, let me proceed with a few more items. Class, I would like to touch on presumptive notice. Okay? I would like to touch on presumptive notice. What about presumptive notice? Please bear in mind that if you're confronted with such a problem in the bar exam, presumptive notice only pertains to service of notice of setting. Okay? Notice to a party of a setting of a hearing. Limited lang application yan pag presumptive notice. Therefore, if the notice of setting is served to someone who is outside of the judicial region, class, it is considered as what? It is deemed as served, presumptively served, at least 30 calendar days. At least 30 calendar days from when? From the time that it was mailed. I will repeat. So the reference point here is not the receipt. Sa presumptive notice, the reference point is mailing. So if the case is in the National Capital Judicial Region, let's say in Manila, and the party is to be sent out with a notice or to be the subject of the notice is in Laguna. If it is mailed, okay, he's outside of the judicial region, he's in Laguna, he is considered to have presumptive notice within at least 30 days from the mailing of the court. So he's expected to attend. He cannot say, even if the return is not available to the court, he is expected to return because of this, to appear because of this provision. Because most of the time in the past, the court would say, is there a return showing that the person, that the party received it? Not anymore. On a notice of setting, if you're outside of the judicial region, from the time of mailing, you're given 30 days. So if the court will set the next hearing probably 35 days later, you're expected to appear. If you're within the judicial region, 20 days from mailing, they could set it for a hearing and you're expected to appear. And there's no need for the court to ensure that there was proof of such service. Do you get me? Now, let us now proceed with judgments. Now, I would like you to remember this because you might be confronted with a question involving this. Remember that the court issues orders. Court issued orders. And the court issues a what? A final judgment, a final decision, a final resolution. So that's different. A court issued order is different. A court issued order is different from a final decision, final judgment, final resolution. Final resolution is covered by Section 13 of Rule 13. And the only mode of service, di ba ito class? Di ba in-enumerate ko na yung mode of service kanina? Pero pag judgment class, limited only to personal service or by registered name. Like very clear. Take note. Personal service or by registered name. Except that any party may shoulder the expenses to have the final judgment, decision, or final resolution served by accredited courier, but he will have to shoulder the expenses. I will repeat, he can have it mailed by accredited courier, but he has to shoulder the expenses. And class listen to this. If the service of summons is by publication, the service of the final judgment, decision, or final resolution is also by what? By publication. Okay, are we clear? Now, so this is final judgment, final resolution, and decision. Now, there is also what we call court-issued orders. Yan ang sabi ko sa inyo, court-issued orders. Class ito yung mga denial na motion to dismiss, okay? Order to appear, okay, class, so mga ganon. Order granting the extension of time, mga ganon class. Yan ang court-issued order. And that could be served, class, electronically, okay? May electronically serve what? Orders and other documents to all parties, okay? And will have the same effect, okay? But the paper copy of the same shall be retained on the records. Maliwanag. Iba yun, kasi class, incidents lang ng kaso. Now, let me now touch on one more item before I leave Rule 13, two more items before I leave Rule 13. These are what you call service or filing. Ito class, service or filing that should be still filed or served conventionally. Okay, so these are orders. This could be pleadings or other documents that will have to be served or filed conventionally. And what is that? Personal filing, personal service, or personal filing or service by registered mail, and shall only be served electronically, filed or served electronically, unless cannot be served electronically unless with express permission. I repeat to be very clear. So under conventional filing and service class, it can only be by personal filing or service, personal, or it could be by registered filing or service, and yung conventional. And what are these pleadings? Okay, number one, initiatory pleadings or initial responsive pleading like an answer. Okay, two, subpoena protection order, it means writ of attachment, writ of execution, writ of injunction, they follow. Next, when the documents are so voluminous that it is not one, it is not amenable as they use it, as the provision uses it, to photocopy. For example, the documents is as thick as this, probably around 12 inches. It will be very hard to do it. So here, and based on the provision of the rule, you just have to still file it personally, file it or serve it personally to the rest of the parties. or by registered mail. Hindi lang personal, pati registered mail. And finally, those which are, by their very nature, documents which are sealed and confidential will have to be filed, or served, what? Personally or by registered mail. Again, all of this can only be allowed to be served, or pleadings can only be allowed to be served electronically on documents if upon express permission by the court. That is section 14. Now, let me now discuss on the last item under Rule 15. And what is that? The last item I would like to discuss in Rule 13 is list pendants, notice of list pendants. Just a very short discussion of this, and hopefully you will remember. I discussed this also in the question and answer in civil procedure a couple of weeks ago, but I feel the need to discuss this. Plus, remember, when you talk about notice of list pendants, the subject of the action involves what? Title or rights of possession over a property. Title, possession, or interest over property. It could be in a complaint, or it could be in an affirmative relief as claimed in the answer. So, ang pwede pala class maghingi ng, ang mag-cost ng filing the notice of list pendants ay hindi lang ang plaintiff, pati defendant. If that is raised in the affirmative relief in an answer, affirmative defense or affirmative relief in the answer. So, let me explain this. Very simple. There is a complaint. Okay? Once you file the complaint, you can prepare a written memorandum addressed to the Register of Deeds where the property is located, describing in that letter memorandum or written memorandum letter to the Register of Deeds what the case is about, the title of the case, the docket number, the subject matter of the action, what is the plan, the TCP, and that you would want to cost annotation of a list pendants. Clearly, the defendant in his answer could also, if he claims a right, a title, or a right of possession over the property, can cost the annotation of the list pendants. While it is easy, and remember, when you talk about list pendants, it is an actual judicial proceeding. It cannot be proceeding in a quasi-judicial agency. No, it should be a judicial proceeding pending. Now, while it is easy to cost the annotation of a notice of list pendants, it is hard to cancel it. Why? Because it requires a court order. That is within the jurisdiction of the court. It would require a court order. And when I say that, class, for the court to cancel it, you will have to convince the court that the filing of a notice of list pendants or the application for a notice of list pendants is what? Is only to molest me. Okay? To molest the adverse party. That's why you want it to move. Or it is no longer necessary to protect the rights of the party who caused it to be annotated. So ganun ang notice of list pendants. It is not a right. A list pendants does not establish a right. It does not establish a lien or a encumbrance, but it's only a notice. It says this property is subject of a pending litigation. So everyone who deals with the property will have to accept the outcome of the case. If he's a buyer, he will have to recognize or to respect the outcome of the case. Okay? Now, we will now proceed with summons. Okay? We will now proceed with summons. Now, with summons, class, again, looking at your syllabus, class, you will note that there are a number of items that the bar chairman wanted you to look into for purposes of the bar. Okay? Now, look at this, class. The nature of a summons really is to acquire jurisdiction over the person of the defendant. And it is very important that the court acquires jurisdiction over the person of the defendant upon proper service of summons. And by acquiring jurisdiction over the person of the defendant, class, any judgment will be valid against the defendant. That is why you have summons. To acquire jurisdiction over the person of the defendant, or, of course, it could be voluntary appearance. You voluntarily submit to the jurisdiction of the court. For example, you did not contest the improper service of summons. It was just left outside of your house. Then you filed an answer. You voluntarily submitted to the court. The substituted service, it was left to someone who is not connected to the office, who was just outside of your office saying, Are you from that office? Hindi ako. Iwan ko na lang sa'yo. And then you left it to someone in the office, and then the defendant in that office filed an answer. That's voluntary guilt. So if you seek an affirmative relief from the court without questioning the improper service of someone, they are considered to have submitted to the jurisdiction of the court. Now, again, class, who may serve it? Class, critical yun. Nakalagay dito, who may serve the summons? Class, who may serve the summons? It will be the sheriff, deputy sheriff, or process server. Class, take note of this. The sheriff, process server, the sheriff, deputy sheriff, or process server. But kindly take note, sila yung primary na dapat mag-serve. However, if there is a failure of service of summons, okay, failure. For example, pumunta si sheriff, unsuccessful in service. Wala, sarado. He says the house, there was no one in the house. There's no one in the office. Unsuccessful service of summons, no? What can happen? The court may authorize the plaintiff to serve the summons together with the sheriff. Take note. So this is something that was introduced in the 2019 rules. First time. So if there is failure of service of summons at the onset, then the court may authorize the plaintiff to serve together with the sheriff. Okay? Now, please bear in mind, it is also possible that the plaintiff himself will be authorized by the court to do the service of summons in a number of instances. Take note, mayroong instances na ang plaintiff lamang. Number one instance, if the defendant the defendant to be served is outside of the judicial region. Okay? The plaintiff shall be authorized to cause the service of summons. So if the defendant is, for example, is in Cebu, the case is in Manila, then the court can authorize the plaintiff. This is really for expediency and to save the plaintiff on costs. Kasi class, he will have to shoulder the expenses of the sheriff, to fly to Cebu, there should be accommodation. Unlike if it will be he, probably he may find ways to do it. So if it's outside of the judicial region, the court can authorize the plaintiff to serve summons to someone who is outside of the judicial region. Now, please bear in mind that, of course, it's possible that the plaintiff himself cannot do it. So he could authorize someone else upon a special power of attorney. If the plaintiff is a juridical entity, then he could authorize anyone upon a board resolution, giving him authority to serve the summons. Now, so that's one situation where the plaintiff can be allowed to serve summons to the defendant. Then there is also another instance wherein the defendant can be allowed to serve the plaintiff, not the defendant. The plaintiff will be allowed to serve summons to the defendant. Okay? Now, if the summons is returned without having been served to all of the defendants. So this is a scenario wherein there is one. This is a scenario wherein there are multiple defendants. And probably out of 10, only 4 or 5 have been served successfully. The court shall order the plaintiff to cause the service of summons by other means available under the rules. You know that? So the court could require the plaintiff to serve summons upon the defendant in other means. Failure to comply with that order of the court, sabi niya, the rest ikaw na mag-serve, sabi the court, will result to a dismissal of the initiatory pleading without prejudice. Okay, meaning you will refile it. Except that probably you didn't follow the order, you don't have the means, or probably you don't know how to do it, nagkamali ka. Okay, so the dismissal is without prejudice. However, take note. Remember that a while ago I mentioned that the court can, if it is to be served outside of the judicial region, the plaintiff can be authorized by the court, right? If the plaintiff makes a misrepresentation to the court, take note that if the plaintiff makes a misrepresentation that the defendant was served with summons, and it is later discovered by the court that there was no such proper service of summons, then the case will be dismissed with prejudice. You see the difference? Because this discussion of mine means that you misled the court. You made misrepresentation that there was proper service of summons, so there will be a dismissal with prejudice. And kindly take note, then that proceedings will be nullified. And the and what? And the plaintiff will be meted the appropriate sanctions. Okay, take note of that. As distinguished from a situation wherein there are multiple defendants and only 4 were successfully served by the court, and the court required the plaintiff to serve in the means provided for by the rules. He was unsuccessful. The case will be dismissed. Dismissed without prejudice. Okay, ba? Nakita niyo, magkaiba yung situation. Now, please bear in mind that the summons is what? That the summons will be valid until the defendant is served. Ganun ang ano. The summons will be valid until the defendant is served, or until that summons is recalled or lifted by or set aside by the court. So ganun na class. You don't need to reapply if there is failure of service of summons. So again, the summons shall remain valid until it is served, unless recalled by the court. Take note that. And please bear in mind, an alias summons can only be issued by the court if there is one. The alias summons can only be issued by the court when? In case the summons has been lost or destroyed. Okay? If it was lost or it was destroyed, only then could you apply for an alias summons. Okay? Now, so I think we've addressed this. Now, let us now try to understand. Okay, I will now discuss these items for you, so that I hope that this will help you remember. Class, remember that a defendant could be a natural person or could be a juridical person. Tama? Can be a natural person or could be a juridical person. So, gano'n natin gagawin. So, tingnan natin muna itong natural person. Ano ba dapat? According to the rules, that someone should be handed to him personally. Okay? That is the requirement of the rules. Personally served upon the defendant by whoever is authorized. It could be the sheriff, it could be the plaintiff authorized by the court, handed to the defendant. Now, but there are times, class, that there was refusal to receive summons. Okay? Ayaw tanggapin. Ang tawag dyan, itong susunod kong discussion is tender. Take note that. If there was refusal and within the view, okay, and in the presence of the defendant. So if this is presented in the war exams, the question should appear this way. The defendant was there, he did not receive it in the presence of the sheriff or the plaintiff having been authorized to serve summons. But if he is in the house, he did not know what was left there could be no tender. So remember, it was within the view and in the presence of the defendant. Take note of that. That's what you call a tender. Now, let us now touch on substituted service. Still on an individual, substituted service. Class, remember this. If I were you, I will memorize this. Substituted service will only kick in. Substituted service will only apply if there is at least 3 attempts in 2 separate days. I repeat, if there are 3 attempts in 2 separate days. Okay? That's the requirement. That was taken from the case of Manoto. Okay? The case of Pascual, the case of Manoto. Now, the requirement for substituted service is by leaving copies of the summons to a person who is at least 18 years of age and of sufficient discretion residing there. So if what appears, take note, in the complaint is the residence of the defendant, you will have to bring it to the defendant, hand it to him if he's dead. If there is a refusal for him in your presence, for refusal on his part to accept it, you will have to tender, leave it in his presence and within his view. Or for example, that you try to serve it upon him, he was not there. This is another scenario. You try to leave it to him, he was not there in his house, as provided for in the complaint. But there is someone, at least 18 years of age and reside of sufficient discretion residing therein, you can leave it to him. But kindly take note, you can only leave it to him, to that person, after having attempted 3 times in 2 separate days. Take note, remember that hindi yung sa unang pagkakataon. This has been asked in the bar exams a number of times. So on your first visit, you knock on the door and you said, andyan mo ba si defendant, si Mr. Juan de la Cruz? Sabi niya, ay wala po. Sabi ng asawa, nasaan po? may nasa office. Pwede ba iwan na lang? That's not successful substituted service. There should have been at least 3 attempts in 2 separate days. What I discussed about a person of 18 years old of sufficient age, of reasonable discretion residing therein applies only as substituted service after 3 attempts in 2 separate days. Are we clear? Now, let me now touch on my next discussion. My next point would be if it could also be substituted service can also be made where? In the office. Substituted service can also be made in the office of the defendant. And that is to be consistent with the provisions, class of Section 4 and Section 5, it should be in the address indicated in the complaint. If the address indicated in the complaint is the office address, then you could leave it to a person in charge of the office. And now, a competent person in charge of the office includes those who customarily receives correspondence from the defendant. That's successful substituted service. Again, always remember that there should have been 3 attempts in 2 separate days. Okay? Now, I've received this question repeatedly. Sir, pwede ba sa bahay? Pwede sa opisina? How will you know the address? The address that you will follow is that what is in that complaint. So the 3 attempts in 2 separate days will be the address appearing in the complaint. But sir, I know he is always there in his other house. Sir, I heard that he is in the golf course. Oh, bring it there. You could, according to the case of Sancho, you could leave it wherever he may be found, according to jurisprudence. But if you are to effect substituted service, kung yan, kahit saan, aabutin mo, okay. But if you're talking of substituted service, 3 attempts, 2 separate days. Get me the address indicated in the complaint. Now, it also happens, and watch out for this, in the one exception, hindi pa ito lumalabas. The defendant lives in a condominium building. He lives in a condominium building or in a subdivision or in a village, which is heavily guarded, which has 24 hours security. And then there was refusal on the part. There was a refusal. The sheriff was refused entry, to be more specific. The sheriff was refused entry. And he just, because he was refused entry, can he leave it to the officer of the homeowners, to the condominium corporation officers, or to the chief security, or if it was a village or a subdivision, can he leave it because of the refusal? There was refusal of entry. Can he leave it to the officers of the homeowners association or the chief security? No, not yet. There should be 3 attempts in 2 separate days. Okay, so the 3 attempts in the first paragraph is very important. The 3 attempts in 2 separate days. And can you take note? You cannot resort to electronic service of summons immediately. You will have to seek leave of court, and you will have to convince the court that there is 3 attempts in 2 separate days. So, tapos na tayo sa individual class. Okay? Tapos na tayo sa individual. Pero class, I would suggest, I would think it would be very important for you for us to touch on extraterritorial service because it's in the syllabus. Okay? Sa individual. And I'm referring to section 70 plus maraming potential na tanong dito. Last year, there was a question here. So class, remember that in extraterritorial service of summons, the defendant does not reside in the Philippines. Does not reside, is not found in the Philippines. And the action affects the personal status of the plaintiff or the subject of the property is within the Philippines, in which the defendant has in which the plaintiff or the defendant has a claim or a lien or an interest, whether actual or contingent. Okay? Are we clear with that? So here, class, I will repeat, for extraterritorial service, you have to look at the question carefully and say, does he reside in the Philippines? So if he is an OFW, he has a house here, section 17 is that application. Here, in that situation, it's section 18, temporarily absent. But the manner of service is the same as extraterritorial. The same. What is the manner of service? So again, Plaza, he does not reside in the Philippines. He is not found in the Philippines, and it involves the personal status of the plaintiff, or involves a property of a non-resident defendant. Okay, a non-resident defendant, and he has a lien. That's a claim. There's a lien or an interest therein, whether actual or contingent. Take note, huh? So in that case, how do you serve summons? Personal service. Take note, that's personal service. You would also do it by publication, and service by registered mail of the complaint and the summons in the last known residence of the defendant. I repeat, and service, publication, and service by registered mail in the last known address of the defendant. What is to be served by registered mail? The complaint and the summons. Take note. And number three is what? Number three is as provided in international conventions to which the Philippines is a signatory or the Philippines has acceded. And number four, other modes as the court may deem, any manner the court may deem convenient. In class, there's been a question here. There was this old case of Rodriguez, a 2003 case, and if I'm not mistaken, there's a 2019 case. It's very simple, class. So there are times, if you're confronted with this question, there is the order of the court did not strictly follow what is in Section 17, as in the case of the 2003 case, Rodriguez case, Romualdez case was, it says, okay, serve it by publication. It has to be answered within 60 days. Okay, by publication, to be answered within 60 days. And it did not say that it will be served by registered mail in the last known address. And it only said that it should be served through the assistance of the Department of Foreign Affairs. That's all it says. What did the court say? That it is in other modes as the court may deem convenient. It falls under that. The more recent case was he was not able, and this was a question in last year's bar exams. He was not able to serve summons. The order of the court is by publication, and he was not able to serve it in the last known address. The reason being that the defendant's spouse, who has abandoned the husband, has been away from the Philippines for the last more than 2 decades. So it would have been impossible for him to know the address. So yun ang sabi ng Supreme Court. It could fall under this, other modes as the court may deem convenient, sabi ng court, or that the same has been substantially complied. The plaintiff cannot be faulted for not knowing the residence of the defendant, who has what? Abandoned, who has left him for the last 2 decades. Okay, class? So please take note of that extraterritorial service. But class, if you're confronted with a question involving an OFW, meaning who has a residence here, he is only temporarily absent. And therefore, Section 18 will apply. In such a situation, class, remember, aside from those that I've enumerated, because there is a residence, there, according to the case of Maxine, in other similar cases, as early as 1955, this has already been answered. Anong sabi? There could be service by substituted service. You know why? 3 attempts in 2 separate dates. Pero noon, wala pa yung 3 attempts, 2 separate dates. Kasi yung 1955, wala pa yun. Kaya lang, paliwanag doon, if temporarily absent, and you could establish substituted service, you follow those rules, then substituted service can be allowed. Okay, class? We will now proceed with domestic juridical entity. This will be my last discussion point, juridical entities in summons. But I will slightly touch on also foreign juridical entity for your purposes. So class, remember, if the question is service of summons to a domestic juridical entity, watch out for this. Class, the requirement is you have to serve it to the president, general manager, managing partner, corporate secretary, treasurer, in-house counsel. Class, you know that. However, this provision, 2019 amendment of Section 12, has relaxed it, meaning while you have to serve it to them personally, okay, where they may be found, okay, where they may be found. So they may be found in the office, they may be found somewhere else. What's important is you hand it to them, okay? Now, if, for example, they cannot be found, they are not in the office, you don't know where they are. When the sheriff visits the office, they're absent. So it could be the summons can be left with the secretaries. Okay, If they're in their absence or unavailability, it will be left with their secretaries. Are we clear? So it's as simple now. You could serve it upon those officers, wherever they may be found. It could be in the office or outside of the office, in their absence or unavailability, to their secretaries. If such service cannot be made, it could also be, pag nagkataon, wala rin ng secretary, for some reason, the secretary is also not present or unavailable, you could serve it upon him. Upon a person who customarily receives summons. It could be a mailing department in that office or anyone who has been authorized, probably the front desk of the office, who customarily receives correspondence. Please take note that even for juridical entities as defendants, service can be made electronically. But again, that should be with the permission of the court. It should be allowed by the court, and you will have to convince the court that there should have been 3 attempts in 2 separate dates. I repeat, you will have to convince the court that there should have been 3 attempts in 2 separate dates. Now, let us look at my last point on summons will be foreign juridical entity. Very simple. If the juridical entity is doing business, transacting business, registered in the Philippines, and has a resident agent, no problem, a presence. It could be served upon any agent, any director, trustee, or officer found in the Philippines. May legitimate presence. But if this foreign juridical entity is not registered in the Philippines, but while transacting business and doing business and transacting in the Philippines, but not registered, obviously it has no representative in the Philippines, no resident agent. In that case, service can be made upon him by facsimile, by electronic means, of course, with leave of court. I've done this. I know that there is no office here. I applied in court to serve to the defendant, foreign juridical entity abroad, by electronic means. I could even course it through the appropriate court in a foreign country. I could request a foreign court in a foreign country, for example, in Boston or in Chicago, with the assistance of the Department of Foreign Affairs. I could also apply for publication of summons where, not in the Philippines, but publication using a newspaper of general circulation in the country where the defendant may be found. So if he holds office in Japan, as in one of my cases, it has to be published there. And serving a copy of the summons and the complaint in the last known address of the defendant. Okay? So, I've done it. Oh, hang on. Before I forget, nakalagay nga sa syllabus, mga bigla kayong tanungin. Proof of service. Mabilis lang ito, class. Yung proof of service, of course, it is the sheriff who does that. If it's the plaintiff is authorized, he will have to prepare an affidavit. But of course, if it's the sheriff, it's an official return of the sheriff. The circumstances of the service shall be narrated so that the court would know whether the service of summons is proper. If it's by electronic mail, there should be a printout of the summons served to the foreign juridical entity, just like what happened to one of my cases. They follow? Or, listen to this, paano yung publication? And this is very important. Pag tinanong kayo sa proof of publication, dalawang affidavit ang kailangan mo. Affidavit of the publisher, editor or business manager or advertising manager, showing by affidavit that a copy of the same has been published in their newspaper and attaching the newspaper where it was published. Of course, a copy of the publication will be pasted on the affidavit of the publisher. Then there's also an affidavit. Affidavit of what? An affidavit showing that a copy of the summons and the complaint has been what? Has been an affidavit showing the deposit of a copy of the summons and order of publication in the post office directed to the defendant by registered name in his last known address. So in simple words, class ganito, an affidavit of the publisher showing that it was been published in the newspaper, or an affidavit of the person mailing showing that what? A copy of the order of publication, the summons and the complaint was sent in the last known address of the defendant. That's all. So I'm done with summons. Now, I would like to touch on, class, motions, class. Just a few items. I would like to distinguish non-litigious motion and litigious motion. Class, non-litigious motion need not be subject of a comment of the other party. An example is execution as a matter of right, issuance of motion for issuance of an alias summons or an alias writ of execution. a motion for postponement. All of these motions will not require a comment. Okay? And I will repeat, execution, motion for execution as a matter of right, does not require for a comment. So within 5 days from the filing of the non-litigious motion, the court will have to resolve the motion within 5 calendar days. As differentiated from litigious motion, these are motions which the other party are given a chance because these are contentious motion, if I may use that word. Contentious motion, a motion for intervention, a motion for new trial, a motion for reconsideration, a motion for what? To dismiss. All of these are what? Litigious motion. So the other party is given a period of time of 5 days to file its comment. With or without the comment after the lapse of the period, the court will have to what? To resolve it within the period of 50 days. So you see the difference in the period. On a non-litigious motion, the court has 5 days to resolve it. Without opportunity on the part of the other party to comment. Within 5 days, the court will have to resolve it. On litigious motion, the other party will be given the chance to comment within the period, an unextendable period of 5 days, and the court will have to resolve it with or without the comment after the lapse of the period within 50 days to resolve that. Now, a last point on motions. Watch out for prohibited motions. As I mentioned a while ago, you cannot file a general rule, a motion to dismiss, except on the grounds of lack of subject matter jurisdiction, litispendentia, res judicata, and prescription. You cannot also file a motion for reconsideration on any action of the court on an affirmative defense. Whether the affirmative defense is granted or denied, you cannot file a motion for reconsideration. That's a prohibited pleading. You cannot file a motion to suspend proceedings without a TRO, a preliminary injunction. Okay? So you cannot also ask the court, Your Honor, can we hear motion to hear the affirmative defenses? No more. That's solely the prerogative of the court. That's a prohibited motion. You cannot file for a motion for extension. That's a prohibited motion. Only once, for good and meritorious reason, only for an extension of time to file an answer. A motion for postponement is also a prohibited pleading, except it's based on act of God, force majeure, and physical inability of a witness to appear for a trial or a hearing. Okay? So I'm done with Rule 15. Yeah, done with Rule 15. We will now proceed with the rest of civil procedure. Now, as I was saying, we will now discuss dismissal of actions under Rule 17. Very briefly, there are 2 items that I would like you to remember. The plaintiff can dismiss the action, and that is Section 1 of Rule 17, and that is a matter of right. There being no answer yet filed by the defendant, the plaintiff could file a notice to dismiss his own case. You have to forget about the counterclaim, there being no answer, so there is no counterclaim to speak of. But please take note that a notice of dismissal, once granted, is a dismissal without prejudice. But if you file on the second time, twice, based on the same claim, a similar dismissal by the plaintiff by notice will be with prejudice. Okay? The next item, that is the 2 dismissal rule. The next item is the dismissal of the plaintiff as a matter of discretion. As a matter of discretion, that would require leave of court. At this point in time, take note that an answer has already been filed. So if the plaintiff realizes, he says, I want to dismiss my complaint, for whatever reason that he feels is necessary to have it dismissed, he files a motion for dismissal. Then the court will have to look into the application or the motion for dismissal. If the court, okay, kindly take note, if the court grants it, it does not result to the dismissal of the counterclaim. I would like to be very clear with that. If the court grants the motion for dismissal after an answer has been filed, the counterclaim will have to stand on its own merits. So you will find there a situation wherein the principal plaintiff, the principal complaint, the complaint of the plaintiff may have been dismissed, but if the defendant, okay, would like to pursue the counterclaim, it could stand on its own merits. But the defendant will have to be quick to inform the court within 15 days upon receipt of the service of the motion for dismissal if he would like to prosecute his counterclaim in the same or in a separate action. If he would like to prosecute it in the same action, he will have to inform the court within 15 days from receipt of notice, from receipt of the motion for dismissal. But again, if he doesn't make any manifestation or motion or notice to that effect, he could still pursue his counterclaim in a separate action. And please bear in mind that unless stated otherwise, the dismissal is without prejudice, unless stated otherwise by the court. Now, let us now proceed to Rule 18, pre-trial. What do you need to remember about pre-trial? You will say, sir, your pre-trial is so long. If you've listened to my lecture, try to recall it, but I would like to highlight a few points. Now, remember that there is a requirement under Rule 18 to file a pre-trial brief. And the pre-trial brief should have been filed at least 3 days before the scheduled pre-trial conference. Are we clear? Now, what is the effect of failure to submit a pre-trial brief? That has the effect of absence. Therefore, if it is the plaintiff who fails to file a pre-trial brief, what happens? The case will be dismissed. If the defendant fails to file a pre-trial brief within the period mandated by the rules, then the plaintiff, kindly take note, the plaintiff will be allowed to present evidence ex parte. Please bear that in mind. Under the old rules, that is what you call a situation of as in default. Now, you may forget that phrase for now, but remember, if the defendant, fails to submit a pre-trial brief, as I mentioned, the defendant, the plaintiff, this is equivalent to absence. This explanation that I'm doing right now are the consequences of absence. So the failure to submit a pre-trial brief, whether be the plaintiff or the defendant, will have the same consequences of an absence. As I said a while ago, the plaintiff didn't submit a pre-trial brief, then it will result to the dismissal of the case. If the defendant did not submit a pre-trial brief, then the plaintiff will be allowed to present evidence ex parte. Now, I would like you to be very careful with my next statement. What are the consequences of absence during pre-trial? And the pertinent provision is Section 5 of Rule 18. Please be very careful about this. Under the present rules, under the 2019 rules, both the party and the lawyer must be present. I would like to be very clear. Both the party, plaintiff and lawyer, defendant and lawyer will have to be present during the pre-trial. And therefore, if the plaintiff is absent without an explanation, a reasonable explanation for the absence, even if the lawyer is present, the case will be dismissed. If the lawyer, if the party is present and the lawyer is absent, the same consequence, and there is no explanation, then the case will be dismissed. Are we clear? Now, let us look at the scenario of a defendant. The defendant is present, the lawyer is absent, in light of the policy of the rules now that both of them will have to be present. That's why it uses an and. Then the plaintiff will be allowed to present evidence ex parte. If the lawyer is present, as I said, the defendant is absent, the plaintiff will be allowed to present evidence ex parte. If, let's say, for example, it's the other way around. It is the lawyer who is present, the defendant is absent, or vice versa. The defendant is present, the lawyer is absent, the same consequence. The plaintiff will be allowed to present evidence ex parte. And please bear in mind that the consequences that I discussed with you right now applies to absence during mediation and judicial dispute resolution. Now, the last item that I would like to discuss on pretrial, on the matter of pretrial, is Section 10. What about Section 10? I would like you to remember that today, the court during the pretrial can motu proprio declare a judgment on the pleadings or a summary judgment. What do I mean? Incorporated with the pretrial order, if the court sees that there are no controverted facts, that there is no genuine issue as to material fact, or the absence of an issue, or the answer does not tender an issue. All of this that I've enumerated is either summary judgment or judgment on the pleadings. So if the court, upon examination of the documents, upon examination of the records, the document, the pleading so far submitted, is convinced that he could render either a summary judgment or a judgment on the pleadings, that order, pretrial order, will state that. Okay? But please bear in mind, if the court says that in the pretrial order, it is the duty of the court within a period of 90 days without requiring the parties to submit position papers or memoranda to render what? A judgment. Now listen to this carefully. Listen to my next statement. But this pretrial order, this is not yet the judgment. I would like to be very clear. This pretrial order, class, cannot be subject of an appeal or certiorari. Because all that the pretrial order would say is that this is what the judge will say. Okay, I will render a summary judgment. I will render a judgment on the pleadings. It's not yet the judgment. Kindly take note. So that pretrial order, again, cannot be subject of an appeal or certiorari. But can it be subject of a motion for reconsideration? If you read carefully the last line of Section 10 of Rule 18, there is nothing, class, in that line, the last line or the last paragraph that says a motion for reconsideration is prohibited. Okay, class? Now, let us now proceed. I'm done with this. And before I leave this Rule 18, kindly take note that under the 2019 amendments, the court can now motu proprio, and this is an example, when the court can motu proprio in its own initiative, upon examination of the pleadings and the documents, say, I will render a judgment of the pleadings or a summary judgment. I will now proceed with intervention. Intervention is Rule 19. Now, what about intervention that I would like you to remember, class? A few items that I would like you to remember about intervention. Remember that intervention, class, for you to be able for intervention as a rule to apply, there must be a pending case. And whether it be a plaintiff or a defendant, he would like to intervene or to participate in the proceedings, either as a plaintiff in intervention or a defendant in intervention. Please take note of my next statement. You can only intervene at any time before rendition of judgment in the trial court. I repeat, you can only intervene at any time before rendition of judgment in the trial court. That is the timeline. Now, kindly take note, though, that even if the court has already rendered a judgment, according to the case of Loyuco, if the intervener is an indispensable party, the court will allow it. Why? Because if you refuse the intervention of an indispensable party, the judgment will nevertheless be null and void. That's how important this is. And kindly take note, if you are a plaintiff in intervention, you should have your own cause of action. I will repeat, you should have your own cause of action. And class, whether you be a plaintiff in intervention or a defendant in intervention, there must be what? A legal interest. You should establish and should convince the court that there is a legal interest. Just like my last point on intervention, kindly take note that the court is not required to accept a motion for intervention. That is left to the discretion of the court. Kindly take note that is left to the sound discretion of the court. If the court feels or the court determines that it would be best to protect the interest of the original parties in the proceedings and that the rights of the interveners cannot be prejudiced in a separate action, then the court can deny it. And if the intervention will cause unnecessary delay to the proceedings, the court can deny it. For instance, the case is already submitted for judgment and there is an intervener. Unless there is a good reason, there is a clear legal interest, the court will not allow it. I will now lead you to a discussion of a subpoena. I am now on Rule 21. A few things that I would like you to remember about the subpoena. Number one, there are two kinds of subpoena. Subpoena ad testificandum, to appear and to testify, and subpoena duces tecum, to bring documents as indicated in the application for a subpoena. The next item that I would like you to remember here, class, is this, a motion to quash. Kindly take note that an application or a subpoena ad testificandum can be quashed for the following reasons. That you are not bound thereby. You say, I'm not bound thereby. An example is that I am disqualified. I am the spouse of a party, so I cannot testify against my spouse. You get me? I am not bound thereby, or service of kilometerage, that the tender of kilometrage, witness fees were not complied with. Those are grounds for a motion to quash of a subpoena ad testificandum. The grounds for a subpoena to quash the subpoena duces tecum are as follows: that it is not relevant, okay, these are the grounds; that it is unreasonable. The application for subpoena duces tecum, you would like to bring a truckload of documents which is not established to be relevant, and therefore it is unreasonable and oppressive. And at the same time, there was no tender of kilometrage or witness fees. Please bear in mind. And another ground, another reason, another ground to quash a subpoena duces tecum is that the documents sought to be presented, or the documents that were required to be presented, were not sufficiently described. And this is Section 3 of Rule 21. Okay? So kindly take note that in as a last point, in subpoena duces tecum, it should not only be relevant, but the documents sought to be presented should be sufficiently described. Now, let me now touch on modes of discovery. Yan, dito na tayo, class, ha? Dito na tayo sa modes of discovery. And what are the things or the items that I would like you to remember about the modes of discovery? Class, the following items I would like you to remember. There is a Rule 23. Kindly take note, class. There is a Rule 23. What about Rule 23 that I would like you to remember? This is a deposition pending action. Kindly take note that this is a deposition pending action. And what about this that I would want you to remember? Class, please bear in mind that here, the deponent could be a party to a case or a witness, as differentiated to that of Rule 25. As differentiated to that of Rule 25, what about Rule 25? Under Rule 25, class, the subject of, okay, the written interrogatories under Rule 25 is only what? A party to an action. So Rule 25 is a very limited application. And please bear in mind, if you receive a written interrogatories under Rule 25, this could be a preliminary, number one, to calling that party on the witness stand as an adverse party witness, because that is a requirement before you bring him on the stand, so that he is not surprised. The second is that is a requirement. Service of written interrogatories to a party is a requirement for what? Deposition pending appeal. Okay? Now, so that is Rule 25 with a very narrow application. Now, whether it be, class, whether it be Rule 23 or whether it be Rule 25, you will have to establish, class, these depositions could be used, okay, for whatever purpose. Class, it could also be used to impeach a witness. Kindly take note. This could also be used, especially Rule 23, if the person is dead, okay, sick, or infirm, or in prison, or the witness is more than 100 kilometers from the place where the hearing is to be conducted, or his presence or appearance cannot be procured by a subpoena. Kindly take note, though, and I would like to highlight this, that if the witness is available, the priority is to bring that witness on the stand, okay? But recognizing Rule 130, Section 50, if I'm not mistaken with the number, okay? A deposition, kindly take note, taken in another proceeding, I will repeat, a deposition taken in another proceeding could be used if there is what we call an opportunity to cross-examine. So it's possible that the person is already dead, is not available to testify. In that instance, class, for as long as you're able to show to the court that there was what? It involves the same parties, the same subject matter, and that there was an opportunity to cross-examine, then that deposition may be accepted by the court. Okay? So please bear that in mind. Another item, class, that I would like you to remember is, before I leave Rule 23, class, I would like you to remember this, that the deposition officer in the Philippines could be any judge, could be a notary public, or any person authorized to administer oath as what? Any person who is authorized to administer oath as stipulated upon by the parties. It's also possible that a deposition can be taken outside of the Philippines. I repeat, outside of the Philippines. And before whom can deposition be taken? Deposition can be taken before a consular officer, to a consul agent, or the Secretary of Legation. If a deposition is to be taken outside of the Philippines, it is also possible that it could be through a letters rogatory. And I would like to be very clear that a letters rogatory is a communication from one judicial authority to another. For example, a court of Manila communicating to a court of Chicago. That is an example of letters rogatory. And if that is entertained, the request to take the deposition of a person, for example, in Chicago, okay, by a court in the Philippines, the rules that will have to be followed in the taking of the deposition of that person in Chicago will be the rules of deposition in that jurisdiction. Another item that you will have to remember, for example, the taking of deposition of someone who is outside of the Philippines, it could also be by commission. The court can designate, the court can appoint someone. Take note, the court can designate or the court could appoint someone. That means commission. Someone has been commissioned. So if someone outside of the Philippines has been commissioned, appointed by the Philippine court to receive the deposition of another, please bear this in mind, the deposition of another, then the rules of the Philippine court, the rules of the Philippines or the Philippine jurisdiction will have to be followed because it was the appointing authority, the court in the Philippines. Are we clear? Now, let me now proceed to Rule 24. What about Rule 24 that I would want you to remember, class? Before I proceed with 24, always remember, class, before I leave 23, matras lang ko na konti. Any matter could be subject of deposition for as long as it is relevant. Any matter can be subject of deposition for as long as it is relevant and it is not privileged. Having said that, I will now touch on very briefly on Rule 24. And what about Rule 24 that I would like you to remember? Just two items. Rule 24 covers what? Deposition before action. So the filing of the action is purely to what? To get the deposition of the person named and designated in the petition. And kindly take note that this kind of petition under Rule 24, deposition before action, has a special rule on venue. I will repeat, it has a special rule on venue. What is that? The action shall be instituted in the place of residence of the would-be adverse party or the prospective adverse party. I'd like to be very clear with that. Now, Rule 24 also covers deposition pending appeal. I also mentioned that a while ago, class, deposition pending appeal. And class, I would want you to remember that when we talk of deposition pending appeal, class, there is already a final judgment, not an interlocutory order, a final disposition of the case, and that the party applying for deposition pending appeal foresees that there could be further proceedings, And knowing that there could be further, or anticipating that there could be further proceedings, what will he do? He could apply for a motion to take deposition of a person described in the motion, identifying the person whose deposition is to be taken, the subject matter, and the reason, and that is to be filed in the court that rendered the judgment. Okay, class, let us now proceed to my next point. Just a few more items on modes of discovery. I would like you to take note of Rule 26, a request for admission. Kindly take note that unlike the others, Rule 23 and Rule 25, that there could be an ex parte application. And that's really a reflection of the policy now of the rules, that the court promotes the taking of a deposition. But in Rule 26, class request for admission, you could only apply for a request for admission after what? After issues have been joined, meaning after an answer has been filed. Now, what is the subject of a request for admission? Number one, relevant, material, and relevant fact indicated in the request. Number two, the genuineness and due execution of the document that is appended to the request for admission. Now, what is the effect if you fail to respond? If you fail to object to a request for admission, that would amount to an implied admission. That would amount to an implied admission, and that will result to a judicial admission under Rule 129, Section 4. And the purpose of a request for admission as a mode of discovery is to dispense with proof. Okay? So if there is that's why there is a request for admission, so you do away with proving that fact because the other party admitted it. If it's a document that he wants you to admit, he attaches a copy, he would want you to admit the genuineness and the execution of the document, there will no longer be a requirement, or the requirement of Rule 132 on authentication of document need not be followed, meaning it's no longer necessary because the party admitted the genuineness and the execution of the document. Now, the next item that I would like to discuss with you would be Rule 27. Class, Rule 27 appears to be just a single section, but this is important for you. Please remember this, that the subject of a motion for production of books, papers, and documents are matters which are relevant and not privileged, similar to Rule 23, relevant and not privileged. And please bear in mind that when you apply for a Rule 27 motion for production of books, papers, and documents, it does not mean that you are using this or you are presenting this for trial, or you will present this during trial. It only means that you may want to examine it. You may want to look into it because it's a mode of discovery and you will have to decide whether to use it at some future time. Now, kindly take note that that section also is not limited to production of books, papers, and documents, but that section, class, also covers what? That section also covers an order that would allow a party to enter into the premises. So what you have to bear in mind is that there is a property that you have to enter into the premises to allow you to examine, to photograph, to view, to survey. So Rule 27 also covers that. So that falls under Rule 27, not only production of books, papers, and documents, but also to allow you to enter into a the premises of a real property to survey, to picture, to examine, okay, or to measure. Now, let us now move on to Rule 28. And this is the last of the modes of discovery. This is the last of the modes of discovery. Physical or mental examination. And I would want you to remember this as you take the bar exams. If this question is presented to you, remember that you can only apply for a physical or mental examination as a mode of discovery if the physical or mental condition is in controversy. Kindly take note. So you cannot file a sum of money and request against a defendant, request the court, Your Honor, can I apply for a physical or mental examination of the obligor or the defendant? You cannot do that. So you will have to convince the court that a party's physical or mental condition is in controversy, and it should be upon motion and it should be ordered by the court. Physical or mental examination. So this is a provision that has a very narrow application. Let me give you an example of a case that may allow a physical or mental examination, a petition for guardianship. Okay? I'm done with that. I will now proceed with my Rule 29. Kindly take note that Rule 29, class, is not, please bear this in mind, that Rule 29 is not a mode of discovery. Please bear in mind that Rule 29 is what? Rule 29 are examples or instances or consequences for non-compliance. Let me give you an example. If the opponent refuses to give an answer to a question, if you look at the provision in Section 1 in relation to Section 3 of Rule 29, the court could dismiss it. But before the court will dismiss for refusal to answer by the deponent, there must be an order from the court to compel to answer. Only after the court issues an order compelling him to answer and he refuses to comply, only then will the court dismiss the case. And this is consistent with the Arellano case. Now, kindly take note, class, that there are other consequences for other consequences for non-compliance. For example, class, if, as I said, he refuses to obey an order of the court to answer, or there is what? Non-compliance with a Rule 27, production of books, papers, and documents, or to permit entry into the premises, or what else? Failure to comply with the Rule 28, physical or mental examination of a party. But kindly take note, while these consequences of dismissal, judgment by default, or allegations could be stricken out, can apply, or pleadings could be stricken out from the records, the consequence of arrest. Kindly take note, the consequence of arrest will never, for disobedience, will never apply to a person who is subject of a physical or mental examination. That is found in Section 3. My discussion is found in Section 3 of Rule 29. Okay, now I will now proceed with Rule 30. Okay, let us now discuss Rule 30. What are the items that I would like you to remember about Rule 30? Just a few items I would like you to remember. The first, please bear in mind that the plaintiff is given 90 days to present evidence. The defendant is given 90 days to present evidence. And of course, the third-party complainant, the counterclaim, or the cross-claimants are given a period of 90 days. Please bear in mind, taking together all of these presentations of the parties, the period for presentation of evidence should not exceed 10 months or 300 days, okay? 300 days. And please bear in mind, from the time that the case is submitted for decision, it is the duty of the court to render a decision within a period of 90 days from the time it's submitted for decision. And that is clearly provided for in Section 1. Please bear in mind, class, and I've repeatedly mentioned this, that the only grounds for postponement are the following: force majeure, act of God, and physical inability of the witness or the party who is due to testify to appear. Physical inability. But kindly take note that the provisions of Rule 30 retained the requisites for what? For a postponement by reason of the illness of a party or counsel. Kindly take note of the requisites. Number one, that the presence of the party or the witness is what? Indispensable. Okay? Meaning it is indispensable for the proceeding to continue. Number two, that the nature of his illness is that which would render his absence excusable. Okay? Please bear that in mind. Now, kindly take note, class, of two more items that I will mention in relation to Rule 30. Two more items that I will mention. The last of the two would be order of what? Oral offer of exhibits. The requirement today, class, is after the presentation of all the witnesses, for example, of the plaintiff, the formal offer of exhibit should be orally made. Okay, I would like you to remember that. This is consistent with the judicial affidavit rule. And finally, class, while the general rule is, it is the judge who will receive the evidence, I will repeat, that it is the judge who will receive the evidence, but, please bear in mind, but the judge can deputize, okay? Or the judge can delegate the reception of evidence in certain cases to the clerk of court. In what instances? Number one, in ex parte proceedings. Number two, in default cases. And number three, if the parties stipulate. Kindly take note of that. Consolidation. I'll repeat, consolidation. Please bear in mind that when we talk of consolidation, there are already pending cases. And because there are pending cases and it involves common fact and common law, it will be what? It could be consolidated in one action. And once consolidated, the court can already render a judgment. Kindly take note, that is the concept of consolidation. There is common fact and there is common law, and if the court is convinced, subject to its discretion, that indeed there's common fact and law, then the same can be what? Consolidated. And please bear in mind, this could take place in the same judicial station, meaning Regional Trial Court of Makati, and the court which carries or holds the lowest number, meaning the lowest docket number, meaning the court that who received the case that was first filed, then everything will be consolidated to that court. Okay? Now, it is also possible, according to the case of Zulueta versus Asian Brewery, that it can be in two different judicial stations. In this case of Zulueta versus Asian Brewery, it is in the province and one is in Makati. And because it involves one distributorship agreement, then the court says it could be consolidated because it involves common fact. Okay? Now, let us now proceed to Rule 33. Very briefly, class, remember, under Rule 33, this is demurred to evidence. Now, at this point in time, considering that you are already in Preweek, this is already Preweek, I will compare demurred to evidence in criminal. Okay? Please bear in mind. In civil demurred to evidence, civil, after the plaintiff has completed presentation of evidence and that the defendant is convinced that there is no prima facie case established by the plaintiff, and after the plaintiff has submitted his formal offer of exhibits, and the defendant is already commended, and the court probably has acted upon the formal offer of exhibits. Now it is time, we could say that the plaintiff has completed the presentation of evidence, and the defendant can file a demur to evidence. I'll repeat, a demur to evidence, and the objective of which is what? The objective of which is to dismiss the case, okay? Is to dismiss the case. Now, kindly take note that a demurred to evidence shall be subject of Rule 15. What does it mean? That it is like a litigious motion. Now, you have to watch out for this, class. An order denying a demurred to evidence, I repeat, an order denying demurred to evidence shall not be subject of an appeal or petition for certiorari, prohibition, and mandamus. Because the objective is, if it's denied, you now proceed to the presentation of evidence. Take note, the defendant will have to present evidence. But of course, if the court renders a judgment later on, you could avail of the remedies for a final judgment. Now, let us twist the facts a little bit. Sir, what if the court, sasabihin mo sa akin, sir, what if the court grants the demurred to evidence, so it dismisses the case? It's an adjudication on the merits. It's an adjudication on the merits. Therefore, the remedy, if the court dismisses it, is an appeal. Take note, is an appeal because it's an adjudication on the merits. Now, let us now proceed with, very briefly, with the demurred to evidence in criminal cases. This is in Rule 119, Section 23, if I'm not mistaken. Now, what you have to remember is that unlike civil cases, I will repeat, unlike civil cases, it is highly recommended that the defendant, after the prosecution has rested its case, more or less the same. It's the same. Formal offer of exhibits, the court admits the same, then the plaintiff or the prosecution is considered to have rested its case. Sir, but pinag-iba pa pangalan? Ganun. But to reach that point, it's the same. Okay? So when the prosecution has rested its case, it is highly recommended that the defendant will seek leave of court. Although it's not mandatory, you're asked the court, Your Honor, may you allow me to what? Please allow me to file a demurred to evidence. If the court grants it, and that leave must be filed within a period of 5 days. If the court grants that leave, meaning the court says, okay, please, you can file a demurred to evidence, then you have to file it within a non-extendable period of 10 days. Okay? The leave is important, class, because in the absence of leave and the demurrer is denied, the court can already render a judgment in a criminal case. You see the difference? That's why a leave is highly recommended. I'm not saying it's mandatory, but it's highly recommended in a criminal case. Okay? In a criminal case. Although, backtrack a little, civil, I will repeat, civil, okay, there is a different consequence for civil. Class, umatras ako ha? Huwag niyo paghaluin, ito civil. The demurred to evidence is what? Of the defendant was granted. Meaning the case was dismissed. The plaintiff appealed. I'll repeat, the plaintiff appealed. I'm referring to a civil example, Rule 33. The plaintiff appealed. And the court granted the appeal. The defendant who filed demurred to evidence in the trial court would no longer be allowed to present his evidence. Okay. That's the consequence. That's the risk that you take in a civil case. Now, let us now proceed with the remaining provisions, of what? The 2019 amendments of civil procedure. Please bear in mind, whether it be a Rule 34 judgment on the pleadings or summary judgment, class, today the court can motu proprio render a judgment on the pleadings or motu proprio render a summary judgment. But class, kindly take note, the option or the right of the party as to Rule 34 of the plaintiff after receiving an answer to file a motion for judgment on the pleadings remain. I will repeat, today the plaintiff can still file a motion for judgment on the pleadings, but the court motu proprio can file a judgment. The court can motu proprio render a judgment on the pleadings. Now, please bear this in mind, that judgment on the pleadings, the answer does not tender an issue or otherwise admits the material allegations of the complaint. And please bear this in mind. If the court, just like my discussion in Rule 18, Section 10 a while ago, if the court says, okay, I will render a judgment on the pleadings, sasabihin ng court, I will render a judgment on the pleadings, the action of the court shall not be subject of an appeal, certiorari, prohibition, or mandamus. But of course, class, there is nothing preventing him from filing a motion for reconsideration because there is no prohibition. But he cannot, what? That action, sasabihin ng court. Your Honor, ano to? I will, sabi ng court, I will render a judgment on the pleadings. That cannot be subject of an appeal, certiorari, prohibition, or mandamus. Now, let us now look at a summary judgment. Kindly take note that the summary judgment is filed if what? There is no genuine issue as to a material fact. I'll repeat, there is no genuine issue as to a material fact except as to the amount of damages. Please bear in mind that there could be a partial summary judgment and there could be a complete summary judgment. It is also possible that the plaintiff can file a motion for summary judgment after an answer has been filed. Okay? Claimant, only after what? At any time after the pleading in answer thereto has been filed. So the plaintiff can only file, okay? The plaintiff can only file a motion for summary judgment after an answer has been filed. But if it is the defendant who will apply for a summary judgment, it could be filed at any time. Now, please remember my next statement. Just like a judgment of the pleadings, the court here can issue an order saying, I will render a summary judgment. I will repeat, the court could issue an order saying, I will render a summary judgment. In that case, kindly take note that order, okay, of the court saying that it will render a summary judgment, motu proprio, cannot be subject of an appeal, certiorari, prohibition, or mandamus. Okay. Now, I will now proceed with appeals, with remedies. Okay. Class, ha? Tandaan nyo to, itong remedies, we will discuss this thoroughly. We will discuss the rest of the provisions, and hopefully we are able to complete it. Okay? Now, what are the things that I would like you to remember? Remember, class, that the following are your remedies within the reglementary period. Tandaan nyo, huwag nyo kakalimutan to. Within the reglementary period, the remedies, number one, from an adverse judgment, motion for reconsideration. And the motion for reconsideration is rooted on, you're saying it's contrary to law, your Honor, the decision is contrary to law, the award of damages is excessive, and it's not supported by evidence. Okay? During that reglementary period, you can also file a motion for a new trial on the grounds of what? Newly discovered evidence, or that there was extrinsic fraud, accident, mistake, or excusable neglect. Kindly take note, huh? Kindly take note. Motion for a new trial. In class, you can file, unlike a motion for reconsideration that you can only file once, a motion for new trial, there could be a second motion for new trial if the ground was not yet available at the time of the filing of the first. Now, during that reglementary period, class, you could also file an appeal, class. But kindly take note, a motion for reconsideration or a motion for new trial is not a prerequisite to an appeal. Now, let's do some exercises, okay? Let's do some exercises. What is your remedy from a judgment of the MTC? From a judgment of the MTC, class. If it is the judgment, and listen, you file a notice of appeal. And the period that you have is a period of 15 days. Unless it is a special proceeding or a case involving multiple appeals, then you will file a record on appeal. And your period is 30 days. Either way, a motion for reconsideration is not a prerequisite. Now, so that is ordinary appeal. Now, how about from a judgment of the RTC? Class, listen to my example. From the RTC, the judgment of the RTC could be what? It could be original action. It could be appellate. De follow? It could be original jurisdiction appellate. So let us look at the first scenario. The first scenario is the RTC rendered a judgment in the exercise of its original jurisdiction. So you will have to determine ano bang kaso. If it's ordinary cases, you will file a notice of appeal within a period of 15 days. But if it's the type of, let's say, for example, expropriation that is subject to multiple appeals, they follow, you would like to question the order of expropriation, you will file a record on appeal because the original records will be kept by the court to determine just compensation. So within a period of 30 days, kindly take note, within a period of 30 days, record on appeal. Now, it's also possible that the RTC is exercising appellate jurisdiction, meaning it previously originated from the MTC. It's already now being reviewed by the RTC as an appellate court. Now the appellate court renders a decision and you're not happy with it. You will go up to the CA. Do you get me? You will go up to the CA on a petition for review. Within a period of 15 days, I will repeat, within a period of 15 days, you will file a petition for review. Unlike if it's a court of original jurisdiction, you could either file a notice of appeal or a record of appeal. But whether it be a notice of appeal or record of appeal, it goes to the CA, Court of Original Jurisdiction, RTC. But if it is the RTC in the exercise of its appellate jurisdiction, yes, but not on an ordinary appeal, you go up on a petition for review, also with the CA. Are we clear? Now, let us now look at the Supreme Court. Kindly take note, class, that to go up to the Supreme Court is only a pure question of law. I repeat, only on a pure question of law. But before I discuss the Supreme Court, I may forget one thing. It's also possible that there are certain cases will originate from quasi-judicial agencies like Civil Service Commission, GSIS, SSS, they follow, DARAB, class. You will go where? To the Court of Appeals on a Rule 43, and you call that a petition for review to be filed within a period of 15 days. That 15 days could be extended, okay, for another 15 days for good and compelling reason upon payment of docket fees. A second extension generally is not allowed except for compelling reasons. I will repeat. A second extension is not allowed except for a compelling reason. So Rule 42 and 43 on matters of extensions are the same. Okay? Now, let us now look at Rule 45. Ayan, punta na tayo dito, class, sa Rule 45. Class, sir, what about Rule 45 that you would want us to remember? Remember the basic rule. The only way to go up to the Supreme Court, is in civil cases is Rule 45, petition for review on certiorari or what you call an appeal by certiorari within a period of 15 days. Maliwanag? General rule. Civil cases, the only way to go up to the Supreme Court is a Rule 45. Okay, 15 days. Now, how about criminal cases? Criminal cases, listen, whether it be civil, whether it be criminal cases, you go up to the Supreme Court on a Rule 45, except that in criminal cases, that remedy of Rule 45 will not apply if it is what? If the penalty is death, life, reclusion perpetua. We will discuss that when we reach our discussion on criminal procedure. Tandaan nyo yun, ha? But for civil cases, the only way to go up to the Supreme Court is on a Rule 45, appeal by certiorari or petition for review on certiorari. The period to file it is a period of 15 days. So all of this remedies are available during the reglementary period, class. It's also possible, class, that the judgment has already attained finality, meaning it's already final and executory. The remedies are, it could be a petition for relief from judgment. But please bear in mind, if it's a petition for relief from judgment, the grounds are fraud, accident, mistake, excusable neglect, and that the period is counted from within 6 months from entry of judgment. Listen, within 6 months from entry of judgment, but within 60 days from knowledge. So the real period is just 60 days, but that 60 days should move around That's 6 months within end of judgment. If you learned of the judgment at the end, almost at the end of the 6 months from the end of judgment, you are left with the remaining period. Okay, now let me now touch on annulment of judgment. Annulment of judgment is another remedy, extraordinary remedy, if the judgment is already final and executory. And kindly take note, class, that this annulment of judgment cannot be a remedy if it's the fault of the party. Okay? Now, let us look at this. Applying for it. Now, what are the grounds? Extrinsic fraud only. I will repeat. Extrinsic fraud only. Number two. Okay? Number two, lack of jurisdiction. It includes lack of subject jurisdiction or lack of jurisdiction over the person of the defendant. And number three, lack of due process, which is provided for by jurisprudence. The period to file a petition for annulment of judgment, if the ground is extrinsic fraud, is 4 years from discovery. If the ground is for lack of jurisdiction, before it is barred by laches and question of jurisdiction. Are we clear, class? Those are the periods. And please bear in mind, class, that if upon filing of the petition with the Court of Appeals, the Court of Appeals finds due course and finds prima facie case, then they will require the respondent to file an answer. A very unique one, a very unique process. Here, the only instance where the Court of Appeals will issue summons and will require the defendant to file an answer. And the procedure to be followed as expressly provided for by Rule 447 would be the procedure for what? Ordinary civil cases. I will repeat, ordinary civil cases. Not proceedings in the rules in the Court of Appeals, but ordinary civil cases. Now, there was a question during the question and answer. Sir, MTC, can it be subject of an annulment of judgment? Yes, Rule 47, Section 10. But that will be filed in the RTC. I will repeat, that will be filed in the RTC and not in the CA. Okay, I'm done. We will now proceed with execution. Rule 39. Let us now start with execution. And I would like to discuss Section 6. Please bear in mind, class, that Section 6 is an action for revival of judgment or by an independent action. Listen, class. Once a judgment becomes final and executory, let us say it became final and executory on June 1 of 2014. I repeat, June 1, 2014. Within 5 days, not 5 days, within 5 years from entry of judgment, you could file a motion for execution as a matter of fact. Kindly take note, within 5 years from entry of judgment. So you could enforce the judgment within 5 years from its entry. Now, after the lapse of 5 years, but not exceeding 10 years from the entry of judgment, which is the prescriptive period of a judgment, you could file a petition for revival of judgment. I repeat, within 5 years from entry of judgment, a motion. After 5 years from entry of judgment, but not more than 10 years, you could file a petition for revival of judgment. And please bear in mind, listen, you could file a petition for revival of judgment, class, but there is no need to relitigate the case. You don't need to present the witnesses once more because your intention is only to revive the judgment. And please bear in mind, under the expedited rules, if the judgment that you are to revive is a judgment of the MTC, I will repeat, if the judgment that you are to revive is a judgment of the municipal or metropolitan trial court, then it will be subject of a summary procedure. Now, sir, how about a revival of judgment? A revival of judgment of the RTC? Yes, you can also have it revived, class, but again, it may not be summary. It may not be summary procedure, class. It may not be summary procedure, but again, you don't need to relitigate it. You don't need to present the witnesses once more because there's already a judgment and you have a valid judgment. Now, let us now proceed, class, to my next discussion and execution. I would like to touch on money judgment, and this is Section 9. What about money judgment that you have to remember? Remember that before if there is a money judgment, the sheriff must first make a demand. Kindly take note. The sheriff must first make a demand for the judgment obligor to pay. That is his duty based on the provision of Section 9. Now, if Okay, if the judgment obligor decides to pay, listen, and this is the ideal situation, payment should be made to the judgment obligee. Okay, if the judgment obligee is not available, to the representative, authorized representative of the judgment obligee. If the representative of the judgment obligee is not there, then the sheriff could have it delivered to the clerk of court. Okay, and once delivered to the clerk of court, it will be deposited for the account of the judgment obligee in a government depositary bank. Now, it's also possible that payment of money. It's possible that the judgment obligor has no money to pay the award. In that case, there could be levy of real or personal property. Please bear this in mind. The judgment obligor is given the choice of which property he would want to be surrendered to satisfy the judgment, because that's the essence of execution. The properties that he would want to surrender or to allow to be executed on. That is an option given by the rules to the judgment obligor. But if he doesn't make a choice, personal property will have to go first. Now, the next is what we call garnishment. And the best example of this would be deposits, royalties, commissions, annuities. And the ones in custody of the same will receive that notice of garnishment. And the objective of which is to satisfy the judgment. Once there is receipt of the notice of garnishment, and the custodian, including the bank, if it's a bank deposit, will have to report to the court. And if the court is convinced that there are funds available based on the report given to it by these custodians of the funds or annuities or the commissions, then what will the court do? The court will issue an order of release of funds. And those funds should be used to pay the judgment in favor of the judgment obligee. And the funds would have to be released within a period of 10 days. Yan ang money judgment. The next item that I would like to discuss with you is specific act. And you take note of that, is specific act. And the thing that I would like you to be reminded with when it comes to specific act is this. It could be that the court can order that something is to be done, that let's say a document will have to be executed, that a title will have to be conveyed. So the court may require a party to the case to do it. If he does not do it, the court may require someone else to do it. Or if that person designated by the court to do it still refuses to comply, then the court can issue an order requiring it to have been complied with. And therefore, that order shall be sufficient to be submitted to the Register of Deeds to convey title or to pass title or ownership. It's also possible that the court can order a sale of a property. The court can order specific act to transfer possession. The court can also order removal of improvements. But kindly take note, while the court can order all of this, a demolition of improvements or a demolition of property cannot be effected except upon a special order of the court, subject of a proper notice and hearing. Otherwise, that will be invalid. There must be a special order of demolition. Kindly take note of that. Now, the last item that I would like to discuss with you, or probably another one, two more, the first would be when property of a third party is levied. Okay? Now, let us look at this example. The objective of the judgment obligee with the assistance of the sheriff is to execute, correct? If a particular property is the subject of execution, a particular property, and there's a third party claimant, and that is section 16 of Rule 39. What is the effect? If he submits an affidavit to the sheriff and serves a copy to the court, the entire execution or the execution of the property will be suspended. Take note. And for the execution to continue, it is the duty of the judgment obligee, I repeat, to post a bond in favor of whom? In favor of the third party claimant. You take note. If, please bear this in mind, the third party claimant, being a stranger to the action, can vindicate his right if he feels the actions taken are wrong. Okay, he could vindicate his right where? In a separate action. The judgment obligee who felt that his right has been violated or that the claim was frivolous can vindicate his right in the same or in a separate action. Now, kindly take note, as I mentioned in the question and answer forum that we had a few weeks ago. Now, please bear in mind that if there is failure to fully satisfy the judgment, one of the remedies available, for the judgment obligor under section 36, sections 36 and 37 are the following. First, they can call on the witness stand. Okay, they can call on the witness stand who? Okay, they can call on the witness stand the judgment obligor through a subpoena, and they can also examine on the witness stand the obligor, the debtor of the judgment obligor. Take note of that. And once the court is satisfied that indeed there are properties in the custody of the obligor or the debtor of the judgment obligor, and that will be charged. That cannot be moved anymore. Okay? So I will now lead you to the effect of a judgment. Of course, it is an effect of a domestic judgment is, of course, res judicata, you know that, or conclusiveness of judgment. Now, what is the effect? What is the effect? The effect class of this are as follows. Okay. The effect are as follows. First, if it's res judicata, it means that you cannot refile the case anymore. Meaning, the issue has been ruled upon by the court and the matter has been put to rest. For example, the validity of the contract, it's done. So what's the difference between that and conclusiveness of judgment or preclusion of issue? While the court may have resolved the matter of validity, there may be other incidents, probably subcontract, okay, related contracts that you will bring to the court at some future time. The determination of the principal contract can no longer be revisited because that is conclusiveness of judgment or otherwise preclusion of issue. We are now on provisional remedies. There are just 3 items on provisional remedies that I would like to discuss with you. So just please bear with me. Number 1, preliminary attachment. Please bear in mind that the preliminary attachment could be applied ex parte, as part of an initiatory pleading, or upon motion. Second, please bear in mind that a preliminary attachment could be asked at any time before entry of judgment. Therefore, it could be applied in any level of court, any level of the judicial system. It could be applied in the MTC, RTC, Court of Appeals, or Supreme Court. The next item I would like you to remember that in case of an ex parte application, at the time of application, there is no need for jurisdiction over the person of the defendant. At the time that the court issues the order granting the attachment and requiring the posting of the bond, there is no need for jurisdiction on the part of the defendant. And number 3, class, which is the 3rd stage, consistent with the case of Davao Light, class, the 3rd case, upon the implementation of the writ of attachment, the order with the writ of attachment, then at this point in time, there should be service of summons. That's why there is a requirement under Section 5 of Rule 57 of service of summons prior to or contemporaneous with. Okay. The next item that I would like to discuss with you, class. The next item I would like to discuss with you are some of the grounds. Please bear in mind, class, that if there is a claim for money by itself, you cannot apply because it's a huge amount of money, you cannot apply for attachment. You will have to show that it could arise, that the obligation to pay money could arise by reason of law, contract, quasi contract, delict, quasi delict, and that the defendant is about to depart with intent to defraud. Another situation would be that there is an abuse of trust and the defendant misapplied, misappropriated, or embezzled funds with abuse of trust. It could be a factor, broker, or agent, or even an attorney for that matter. Or in an action for recovery of possession of property, unjustly or fraudulently taken, and the defendant tries to remove and dispose of property. In that case, you could apply for an attachment. You could also apply for an attachment if there was what you call fraud in contracting the obligation. That if not for the fraud, that was the proximate cause, that was the reason why you entered into that contract, that you could apply for attachment. Or there was fraud, well, apparently at the start, it appears to be a fair and an arm's length transaction. But in the course of the proceedings, there is one fraud in the performance thereof. Like, for example, with all due respect, if you are a contractor, you provide substandard materials, which is not in accordance with the specifications of the contract that you intended to really to defraud the government. In that case, that is fraud in the performance thereof. The next one is there is an action against a party, and the party fraudulently disposes of, removes, or conceals property. In that case, you could apply for an attachment. And finally, without the requirement of fraud, if the defendant is not found or does not reside in the Philippines, or service is to be made by publication. But of course, if publication is required to serve summons to you, you are not found in the Philippines, or thus you do not reside in the Philippines. Are we clear, class? I hope it's clear. Now, another item that I would like you to remember, class, when it comes to attachment is how to discharge. Kindly take note, class, that you could only discharge an attachment by a counter bond. I repeat, by a counter bond after it has been enforced. You could post a counter bond or a partial counter bond for a partial release of the property. You could also cause the discharge of an attachment if you could convince the court upon motion that the issuance was irregular, the process was not followed, there was no bond, there was no supporting affidavit, irregular, improper, there was no cause, okay? There was no cause, there was no ground, and the attachment is excessive. Okay, the attachment is excessive, or the bond is insufficient. Okay, those are the grounds to discharge an attachment. Now, please bear in mind, class. Please bear in mind that I will now proceed with preliminary injunction. Class. Kindly take note that the requisites, and please do not go to the bar exams without remembering the following, class. Requisites for a preliminary injunction. Number one, while you could apply for it while the action is pending, take note of that. Take note that the requisites are as follows. The applicant must have a clear and unmistakable right to be protected. Therefore, if the right is questionable, if the right is doubtful, the court cannot issue a preliminary injunction, much less a temporary restraining order. Number two, that if a preliminary injunction is not issued, there is material and substantial invasion of a right. Okay? And number three, there is an urgent need for the writ to prevent irreparable injury to the applicant. These are the requisites that I would like you to remember. These are the requisites that would lead to the issuance of a preliminary injunction. Kindly take note that under the present rules, an ex parte TRO can be issued for 72 hours if there is great or irreparable injury. It is also possible and that only an executive judge can issue a 72 hours TRO. Kindly take note. But plus, kindly take note that another way wherein an ex parte temporary restraining order could be issued could be for a straight 20 days. Take note, 20 days by the court where it is assigned, not the executive judge. I repeat, the presiding judge where it is assigned, to whom the case is assigned, if he could establish that there will be grave and irreparable injury to be suffered by the party. So please bear that in mind. Now, kindly take note that in the trial court, the maximum period of a temporary restraining order is 20 days. In the Court of Appeals, it's a period of 60 days. In the Supreme Court, until further orders of the court, but in certain cases, they've allowed shorter periods, but again, until further orders of the court. So if you're able to get a temporary restraining order in the Supreme Court, if you're able to get a temporary restraining order in the Supreme Court, it is as if you have a preliminary injunction. Now, the next item that I would like you to remember here on preliminary injunction class is how to discharge. Plus, how do you discharge how do you discharge a preliminary injunction? Kindly take note. You could have it denied initially without having been issued. It could be denied, or it could be discharged if you could prove to the court that it was insufficient. Okay. Second, it could be discharged. Ito sa discharge lamang ang grounds. It could be discharged if you could show it upon affidavits of witnesses that there is no basis for its issuance. Or number two, you could convince the court, you could show to the court that the damages that you will suffer, meaning the party against whom the injunction is, preliminary injunction has been issued, is far greater than that of what? Than that of the applicant, and you post a counter bond. So it's not allowed to just post a counter bond. You will have to show that the damage that you will suffer, meaning the person against whom the counter bond is issued, is far greater than that of the applicant, and post a counter bond. Now, let us now proceed with replevin. No one goes to the bar exam room without at least remembering, class, without remembering, one, the affidavit for issuance of replevin. Please bear in mind that this the replevin, the application for a writ of replevin, must be applied at any time before an answer. Very short period of time before an answer. You could apply for a writ of replevin. Now you will tell me, sir, what if an answer has already been filed? Well, you could apply for some provisional remedy, like a preliminary attachment if the grounds are present, but no longer a writ of replevin. Now, let's look at this. And please bear in mind that a writ of replevin is only a provisional remedy given to recover personal property. I repeat, personal property. Please bear in mind, okay, that number one, who could apply for this? Okay, who could apply? The registered owner, okay, the owner, or someone who is in lawful possession, meaning a lawful possessor of the property, probably a lessee of the property, okay, a lessee of a fleet car, okay, fleet of cars. Okay, last, he has what? He is, maybe he's not the owner, but he is what? Entitled to possession. Okay. Number two, that you will have to establish the market value, meaning the value of the property, which is what? Which is twice its value. That's the value of the bond. And why is it important to be stated in affidavit? Because that will be the basis of the bond, which is to double the value of the property. And please, you have to take note, you will have to allege also that there was unlawful deprivation of that personal property. I will repeat, that there was unlawful deprivation. And finally, that the deprivation is not upon a levy, is not upon an execution, is not upon an attachment, or is not upon a tax, distraint, or levy. In all of those that I've enumerated, class, it only means that the deprivation is lawful. And for that reason, you cannot apply for a writ of replevin. Now, please bear in mind that a deprivation by reason of a criminal act, meaning, for example, a car that was used in the commission of the crime was impounded. Let us say there are certain computers that were taken by the court, lawfully taken by the court, that cannot be subject to a writ of replevin. In one case decided by the court, in the case of Nakudag, there were certain forest products that were detained or taken by the Department of Environment, Natural Resources. That was a lawful deprivation, and therefore cannot be subject of a writ of replevin. Now, how could it be discharged? Let us say, listen, this is how it operates, just to refresh you. Remember, class, that when the sheriff comes to that person, probably a case involving a sum of money with an application for a writ of replevin of the car, okay, of a car, or probably it's very common within a banking financial institution would like to recover the chattel, the subject matter of the chattel mortgage, meaning there is an underlying security transaction over the loan, so they would like to recover. Why? Because he can no longer pay the loan. So he would like to take the car. There is a writ of replevin. So imagine I'm the sheriff goes to you, you're the one who's unable to pay, so I will show you the writ of replevin. I will take the car, kindly take note, and I will hold it for 5 days. Kindly take note, I will hold it for 5 days. And you, having been deprived of the car, lawfully deprived of the car, can post what you call a redelivery bond within a period of 5 days. Otherwise, class, once I take it and within a period of 5 days, you're unable to post a redelivery bond, I will give it to the applicant. I will repeat, I will give it to the applicant. As differentiated, class, if it is an attachment, those personal properties will only be placed in custodial aegis. It's in the control of the court, unlike in replevin, class. So in attachment under Rule 57, the court takes, okay, and during the pendency of the case, the personal properties during the pendency of the case will hold on custodial aegis. Unlike in replevin, that specific property, because class, in attachment, that's only a security for the judgment. In replevin, the court takes, holds it, The sheriff takes, holds it, and if there's no delivery bond, delivers it to the applicant. Kindly take note. That's how it operates, class. Now, please bear in mind if the person deprived upon a writ of replevin would like to take immediate recovery, he should simply post a counter bond. I will repeat. Just simply post a counter bond and you will have a delivery bond and you can recover it. Otherwise, if you question the sufficiency of the bond, well, if you could do it, you cannot immediately recover possession of the personal property. Take note that replevin, it's recovery of personal property. In class, my last point on this would be on this point. Remember that in preliminary attachment, injunction, and replevin, Rule 57, Section 20 applies. Remember, class, that the bond that was posted by the applicant for provisional remedies could be subject for recovery of damages. Take note. But please bear in mind that the recovery of damages can only be made by the person against whom those provisional remedies were issued while the action is pending. I will repeat, before trial, while appeal is perfected, and before entry of judgment. In simple words, while the action is pending. Okay? But in that instance, there will be a hearing in the trial court. It's also possible that there is an appeal before the appellate court, and the party was able to establish that the issuance of the writ of attachment or preliminary injunction or replevin was wrong. Then there could be a reception of evidence before the trial court for recovery of damages on the bond. We are now on special civil actions. We're about to complete our review on civil procedure. We may have exceeded a few, probably an hour, but this is just to make sure that the discussion is comprehensive. Don't worry. So the intention is to be as comprehensive as possible. So I think I may have covered instead of 3-4 hours. So don't worry about this. I'll now walk you through, inclusive of this, probably around 4 hours and 15 minutes. Now, let's look at this, an interpleader. Rule 62. What do I want you to remember? Remember that an interpleader, you come to court in order not to be vexed. Kindly take note. So the person filing the action comes to court. There is no violation of his right. He has no interest in the property subject of the controversy, or probably his interest is not inconsistent with the conflicting parties. So what he does is he turns around and tells the court, Your Honor, can you determine the rights of the conflicting parties? In class, once the complaint is filed, the court will issue an order requiring the parties to interplead. Of course, summons will have to be issued. And please bear in mind that this is subject to special rules. And the defendant could file here a counterclaim, cross-claim, or third-party complaint. Please bear this in mind. Now, I would want you to remember, and I will just give you an example of this interpleader, is that, for example, an insurance company is confronted with a problem that there are two individuals claiming to be the spouse of the deceased, both presenting what appears to be authentic marriage certificates. So what will the insurance company do? In order not to be subject of claims for damages, in order not to be vexed, it will ask the court, please determine who between the two is truly the spouse of the deceased, so that we could properly pay the proceeds, the insurance proceeds. So take note, that is the concept of an interpleader. And just one last point before I leave this matter. In interpleader, there is an additional ground for a motion to dismiss. If the grounds are as follows: subject matter jurisdiction, convention, res judicata, statute of limitations, prescription. Another ground for interpleader is what? The impropriety. Okay? Meaning it is not the proper subject of an interpleader. The next item that I would like to discuss with you, class, is declaratory relief. Class, please bear in mind that no one goes to the bar exams without understanding, I don't want to say memorizing, I don't want to pressure you, but without understanding Section 1. Please bear in mind that Section 1 is declaratory relief. You come to court telling the court, Your Honor, can you please determine the validity of a deed, a will, a written document, okay, a deed, a will, a written instrument, a law, a governmental regulation, an ordinance. You're asking the court, please determine the validity or please construe it. Please bear in mind, it's very important that there is yet no breach. The same as interpreted, there is no breach. I take note. But the very moment there is a breach, this is the only special civil action, or this is the only action where there is a conversion from a special civil action to an ordinary civil action. Please bear that in mind. I'm just discussing the declaratory relief portion, the first paragraph. And the action shall be instituted in the regional trial, not in the Court of Appeals, not in the Supreme Court, no concurrent jurisdiction, but in the RTC. All right. Now, the next paragraph that I would like you to remember would be other similar remedies that you could come to the court to say, Your Honor, please quiet title. Okay, class, let's please remove the cloud because there appears to be a doubt on my title. But I would like to caution the class. If it's purely quieting of title or removal of clouds, I think I mentioned this in the original, in the long review class. If it's the objective is just to quiet title, you retain possession, you retain title, the title is with you. But there are just some sort of cloud or doubt. There is a will that floats around. There's a deed of donation that the property was supposedly transferred, but you still are in possession of the same. The action is really to be instituted with the RTC. And the assessed value is inconsequential. Okay, inconsequential. Consistent with the case of Sabitsana versus Ortega. Now, let us look at, there is also what you call reformation. There should be mutual mistake. There is no breach, RTC. And there is what? A consolidation, judicial consolidation of title. This happens in situations of a pacto de retro sale, when the property that was sold is not been what? Redeemed within the period or the conditions mandated. In that case, it will have to be consolidated to the buyer. Okay? That is a judicial consolidation of title, pacto de retro sale. Now, having said that, class, kindly take note. My last point on declaratory relief is this. This is the only case where the court can say it's not yet ripe for judicial determination. And I'm referring to declaratory relief. The court can say, no, I will not resolve this. I will dismiss it because that will not put to rest the controversy. Now, the next item that I would like to discuss with you is certiorari, prohibition, and mandamus. This is in Rule 65. Listen carefully, class. The period to file a certiorari, prohibition, and mandamus is a period of 60 days. That period, as a general rule, cannot be extended, but jurisprudence has allowed an extension for compelling reason. But the period is ordinarily 60 days. Now, please bear in mind that if it is a certiorari or prohibition, the requisites are as follows. Grave abuse of discretion amounting to lack or excess of jurisdiction. Number two, there is no appeal or any plain and speedy remedy. Listen, for certiorari under Rule 65, you are questioning a judicial or quasi-judicial. Okay? Take note. So therefore, if you're asking the court to interpret a circular, an administrative circular of a department or an agency of the government, you don't do a 65. You do a declaratory relief. You follow? Now, it involves judicial, quasi-judicial function. For prohibition, it includes judicial, quasi-judicial, and ministerial functions. For mandamus, kindly take note, there is a law that requires performance. I repeat, there must be a law that enjoins you to do something, that enjoins you to perform. That is mandamus. So it must be ministerial. I will repeat, ministerial. So you are not filing mandamus to require a court to act in a particular manner, to exercise discretion in a particular manner. You're just telling the probably an agency of the government, a public officer, telling them what? For example, please release the title, all of register of deeds, for example, release the title, all of the documents have been submitted. There's already a deed of sale, there is already payment of taxes, there are all payment of transfer fees, all of the requirements are in. You have no choice but to issue a title, ministerial. Another example would be the Office of the Ombudsman. The Office of the Ombudsman has a duty to resolve actual complaints against public officers. But it has been pending for 3 years, 4 years. You can file an action for mandamus, not to compel him to file a case against the person or to punish him or to sanction him administratively, but to tell him to what? To tell him to please resolve it. because that does not require discretion. Remember that mandamus does not require discretion, and there should be a law that requires performance. Okay? I'm done with that. Now, as a last point, remember that in certiorari, if the subject, the order, which is subject of a question of grave abuse of discretion, amounting to lack or excessive jurisdiction, originates from a quasi-judicial agency, then the certiorari under Rule 65 will have to be filed with the Court of Appeals. That is subject to the express provision of Rule 65. Now, let us now proceed to quo warranto. Okay? Please proceed. Let us discuss quo warranto very briefly. Now, what are the grounds? What are the grounds for a quo warranto class? Remember that this is an action primarily, okay? This is an action filed by government. Look at section 1. It is the government that files the action. That's the general rule. Now, there is usurpation, that someone takes on unlawfully the office of another, performs his official duties without a valid appointment, or usurpation. Number 2. By reason of your act, you are deemed to have forfeited the office. You are a congressman of the Republic of the Philippines, and you pledge allegiance to the United States of America, and you are now an American citizen. By reason of your act, no one is interested in your office. You are deemed to have what? Forfeited the office. Number 3. Last. It's a corporation not duly registered with the Securities and Exchange Commission. A corporation not duly registered. Acting as a corporation and association without a certificate of registration, you are subject of a quo warranto action. Please bear in mind, though, that under jurisprudence, if there is a requirement of a legislative franchise or a public franchise, like a law for you to operate, to broadcast, for example, for you to allow you to continue acting, for example, for a TV or for a broadcast network that requires a legislative franchise class or a public franchise, in the absence of that, you could be subject of a quo warranto. There are even some cases, class, where there is a franchise, a live or active legislative franchise, but the conditions thereof are not complied with, are not performed within the periods required or the conditions provided in the franchise, legislative franchise, then that could be subject of a quo warranto. And you take note. Now, the next is, knowing the grounds, who can institute the action? The following can institute the action. Number 1, class, the Solicitor General if directed by the President. Okay, number 2, the Solicitor General upon a sufficient complaint. Number 3, as a Solicitor General upon the relation of another person, meaning there is someone who prompted the Solicitor General. Probably there is an affidavit submitted to him, there is a complaint submitted to him, and he will examine the same, and it was prompted by another person. He could file an action in court, asking the court, Your Honor, can you give me permission to file an action? So if it is upon the initiative of a third person, or who we call a relator, the Solicitor General could come to court and ask for permission to file the action. Take note of that. Now, what else? There is also, under Section 5 of Rule 66, wherein an individual who has been usurped, or who has been deprived of his right to his office, deprived of his office, can file an action for quo warranto. Kindly take note that the singular instance when the person who is entitled to office files an action for quo warranto. But please bear this in mind, according to the case of Liban versus Cordon, that the very moment it appears to the court that the person filing the action is not entitled to the office, the same will have to be dismissed. I go back to the basic rule. What is the basic rule? It is the government who should institute this action, an action for quo warranto. Please bear in mind that this action for quo warranto could be instituted in the regional trial court of the place where the respondent or any of the respondent resides. But if this is initiated by the Solicitor General, it could be initiated in the city of Manila, the regional trial court of Manila. Now, it could also be instituted in the Court of Appeals and the Supreme Court. Court of Appeals and the Supreme Court. Now, let me now proceed to expropriation. What about expropriation that you will have to remember? Class, please listen to my discussion. In your syllabus, it says that the 2 stages will have to be reviewed. Kindly take note that the first stage is the order, is that portion wherein the expropriation stage. And once the court hears it and determines that the government is entitled to possession, to the property, upon payment of just compensation, of course, and to establish that there is a public purpose for its taking, then the court issues an order of expropriation. Listen to this. That complaint for expropriation or petition for expropriation could be withdrawn at any time. This is based on the provision of Rule 67 before an order of expropriation is issued. But because of the special nature of expropriation clause, even after an order of expropriation has been issued, but if it appears at some point in the proceedings that the public purpose is no longer available, I will repeat, the public purpose is no longer available, then the complaint or petition for expropriation can be what? Can be withdrawn. Are we clear? That's the first stage. And considering that that is a judgment, an order of expropriation that is subject of an appeal, or what you call a record in appeal, and the period to file it is a period of 30 days. It is the remedies, not the petition for certiorari, but the record in appeal. The second stage class is the determination of just compensation. I will repeat, is the determination of just compensation. And when I say this class, there should be at least 3 disinterested commissioners. And it is the duty of the court to establish the proper amount of just compensation to the person who has been deprived of this property upon the exercise of the government's and the state's eminent power of eminent domain. Please bear in mind that the formula is consequential damages less consequential benefits. In no way will consequential benefits exceed the damages. Otherwise, the government can just take it without payment of just compensation. Now, class, please bear in mind, I would want you to remember this one. Please bear in mind that once the complaint is filed, class, the state can take, the state or the local government unit or any instrumentality of the government can take immediate possession. How? If it is subject of a government infrastructure project, it should be the zonal valuation or proffered value, 100% of the zonal valuation. That should be paid to the owner of the property to take possession. Okay? Now, when it comes to Rule 67, it's a government infrastructure project, then it should only be a deposit in the government depository bank of the assessed value of the property. Second. Number 3, if it is upon an expropriation of a local government unit, there should be an ordinance, not a lupon, not a sanggunian resolution, but an ordinance requiring that expropriation. Okay? And please bear in mind, it should be 15%. The deposit to take initial possession will be 15% of the fair market value. Okay, now, I've explained that. Another item that will happen, that may happen, class, is that there is a dispute. There are people who claim that they own the property, there's a dispute. Class, under Section 95, if mistaken, of Rule 67, the court has the power to make a provisional determination of ownership as to who will receive the proceeds of the sale. That's within the power of the court. And please bear in mind, as my final word on expropriation, class, on my final word on expropriation, that the plaintiff, of course, will be the government, the local government unit. There must be an ordinance or other instrumentality of the government. Now, the defendant could be the owner, the registered owner of land. It could be a real property. It could be a personal property subject to expropriation, and the action shall be instituted in the regional trial court, regardless of the value of the property. And it could be an occupant or a lawful possessor. Of course, an informal settler is not entitled to just compensation. We will now proceed with foreclosure of real estate mortgage. Kindly take note that I will also discuss not only judicial foreclosure, I will briefly discuss extrajudicial foreclosure, or Act 3135, and RA 8971, Section 47, just to make sure that we've covered everything for this Preweek. Now, please bear in mind, for judicial foreclosure, there is what you call the equity of redemption. And the period is not less than 90 nor more than 120 days. So in an action for judicial foreclosure, alleging that there is an underlying security transaction and there is an obligation to pay, and the court renders a judgment, the judgment will be an order or a judgment to pay. If within the period of not less than 90 nor more than 120 days, which is the equity of redemption, there is no payment made, the foreclosure will take place. The foreclosure sale will take place. Kindly take note. If there is a deficiency, kindly take note. If there is a deficiency, the deficiency after the foreclosure sale shall be recovered in the same action. There was the motion for recovery of what? The deficiency. And to be able to apply for a writ of possession, there should be a confirmation of the sale. Okay? A confirmation of the foreclosure sale. Now, let's look at extrajudicial foreclosure, Act 3135. Now, in Act 3135, kindly take note, it is not filing an action in court as like a regular action where you pay docket fees, where it is raffled to court. An extrajudicial foreclosure is a petition filed with the executive judge, who is also the ex officio sheriff. Okay? Now, it is before the executive judge, and that it's a petition for an extrajudicial foreclosure. Once all the requirements are satisfied, the schedule or the date of the scheduled foreclosure sale will be published in a newspaper, or will be published in a newspaper of general circulation. Now, there will be what you call a publication. Please bear in mind that the redemption period in Act 3135 is a period of 1 year. And who will continue with the possession during that period, whether it be a judicial foreclosure or extrajudicial foreclosure? It will be the mortgagor who will continue in possession of the same. If, for example, in Act 3135, in extrajudicial foreclosure, the buyer, okay, the buyer or the purchaser would want to take possession, he will post a bond. Kindly take note, he will post a bond. Now, let us look at RA 8971. The special feature of 8791 is that the lender, remember this, is a banking institution. If the lender is a banking institution and the borrower, mortgager is an individual, remember that the redemption period is 1 year. Maliwanag? 1 year. And kindly take note who will be in possession. Unlike the judicial or extrajudicial, the traditional judicial extrajudicial foreclosure, under 8791, the possessor will be who? The buyer. Whether the mortgage is the buyer or the purchaser, he will be in possession of the same. Okay? He will be in possession of the same. And as I said, the redemption period is 1 year. If the mortgagor would like to continue with his possession, he will now post a bond in favor of the mortgagee or the purchaser. Now, another scenario for bank foreclosure, if the lender is a bank or a financial institution and the borrower is, or the mortgagor is a juridical entity, the redemption period is shorter. 3 months or 90 days, or registration of the certificate of sale, whichever comes first. It's possible that the sale was today and the registration was tomorrow, it's done, no redemption. But following the provision of the law, it could be a period of registration of the certificate of sale or 3 months, 90 days, whichever comes first. Kindly take note. And that is, please bear in mind, that is for juridical entities as borrowers. Okay. But again, I will backtrack a little. If individuals, the borrower, and the lender is the banking institution, the borrower is an individual, the redemption period, whether it be judicial or extrajudicial foreclosure, is a period of 1 year. Now, let us now proceed to partition. Just a few items that I would like you to remember about partition class. First, in partition, there are 2 stages also. You will have to establish the existence of a co-ownership because all of the co-owners are what you call indispensable parties. Take note of this. And the co-ownership may have been created by reason of law, by reason of the death of an ascendant, which leads to an inheritance. Probably it could be a co-ownership by stipulation of the parties, by contract. Okay, now let us look at this. Once it is determined that all of the co-owners who are indispensable parties are there, then you could proceed to the next stage, of partition. Now, the unique feature of a judicial partition, I would like to be very clear. The unique feature of a judicial partition is that an action is filed in court. And just like a regular case, there will be an answer, there will be pre-trial. Kindly take note, if during pre-trial the parties agree on the partition, then the court will now render, if the parties agree, they enter into a compromise, there will be a compromise judgment. There is a settlement and there will be a compromise judgment, and that will be the partition among the heirs. Now, if the parties, listen to this, if the parties do not agree, and only if the parties do not agree, only then will there be what? If the parties do not agree, appointment of commissioners. Appointment of commissioners who will assist in the partition of the property. And when you talk of partition, it could be real property or a combination of real or personal property. And kindly take note, if I'm not mistaken, this is Section 12 or Section 14 of Rule 69, paramount rights cannot be prejudiced. So if for one reason a co-owner was not impleaded, the judgment will be void. You get me? And therefore, the remedy of the non-impleaded indispensable party is, it could be an annulment of judgment if there is no proper jurisdiction over his person, okay? Or if it is still within the period, according to the case of Alaban, within the period within which to file a petition for relief from judgment. Probably the judgment is already final and executory, but it's still within 6 months from entry of judgment and within 60 days from knowledge, as in the case of Alaban, which is what? It was received sometime in August and he has still 60 days. Then the court said the proper action should have been a petition for relief from judgment. And the court further says that although in that case, the petitioner claims that he is the sole heir, the fact of publication, being an action in him, makes all of the heirs as deemed parties. Sabi ng court, deemed parties, and therefore the proper action should have been a petition for relief from judgment. Now, let me now touch on, very briefly, about forcible entry and unlawful detainment. Now, kindly take note, of course, but if we talk of forcible entry, there is force, intimidation, strategy, threat, or stealth, and there is prior physical possession. In unlawful detainer, the possession was originally lawful, but probably after the lapse of the period, after the breach of the contract of lease, or whatever contract that allows possession, then the possession becomes unlawful. In unlawful detainer, a demand letter is a necessary requirement. And the demand letter should be to pay and vacate or comply and vacate. Otherwise, the demand letter is what? Otherwise, the demand letter is defective and will lead to the dismissal of the case. And please bear in mind that the 1-year prescriptive period for forcible entry or unlawful detainer should be counted from the last demand. It may have been possible that there are successive demands, but the 1-year period is counted from the last demand, not the reminder, but from the last demand. Now, let me now walk you through the new procedure under expedited rules. I've received the question during the question and answer, sir, which will be followed? Expedited rules or Rule 70? Well, to the extent that Rule 70 is still applicable, it will apply. But I tell you, and I will walk you through. Once there is a complaint for rejectment, which falls under expedited rule summary procedure, the period to respond is a period of what? 30 days. And there should be, together with that answer, judicial affidavits, documentary, or object evidence. There is no requirement of a reply. A reply can only be allowed if there is an actionable document attached to an answer. This is summary procedure. Now, please bear this in mind, class. Please bear this in mind. Once summons has been served, wala pang sagot, summons has been served, and the court, after examination of the complaint, is convinced that it has no jurisdiction, there is litis pendentia, res judicata, prescription, the pleading a certain claim states no cause of action, lack of legal capacity, improper venue, non-compliance with condition precedent, class, and class absence of a certificate against forum shopping, or barangay certification, the court can dismiss the case outright without an answer having been filed. Yan ang unique feature ng summary procedure, which applies to forcible and unlawful detainer. Now, the next one is a preliminary conference. The special feature of the expedited rules is that the parties are now required to submit their preliminary conference brief 3 days before the preliminary conference schedule. Now, please bear in mind, paano kung absent the plaintiff? The requirement is the same. Both the plaintiff and counsel should be present. The defendant and counsel should be present. If one of them is absent, the case will be dismissed if it's the plaintiff side. If one of them is absent, it is the defendant class. Then the court, the case will be dismissed if the plaintiff side is absent. If the defendant is absent, the court can already render a judgment. Okay, now, listen, class. Please listen to me. After the preliminary conference, the court will issue a preliminary conference order. And in that preliminary conference order, the court can say, I will already render a judgment. And this is more or less similar as Rule 70. I will render a judgment already. The court can do that based on the available records, but please take note. That order saying, okay, I will render a judgment, class, take note, cannot be subject of a motion for reconsideration, certiorari, prohibition, or mandamus. But of course, that will be questioned later on appeal. Be part of that appeal, the errors that you think there are at that point. Now, please bear in mind that from the time the preliminary conference order is issued, saying that he will render a judgment already, the judgment will have to be released rendered within a period of 30 days. Within a period of 30 days. Now, it's also possible that the court in the pretrial order says, okay, the parties will have to submit position papers. And the submission of position papers will have to take place within a period of 10 days from receipt of the preliminary conference order. Please bear in mind, class, that today, class, the special feature under summary procedure, class, even there will be no trial. And I would like to be very clear, whether in Rule 70, under expedited rules, there will be no trial. So after the submission of the position paper, which is submitted by the parties, if required the pretrial order, within 30 days thereafter, the court will already render a judgment. Now, listen to this. This is still in Rule 70, class. Makinig kayo dito. Now, if there is an adverse judgment, can you file a motion for reconsideration? No. Remains to be a prohibited pleading, whether in expedited rules and in Rule 70. Motion for reconsideration of judgment. Therefore, can you appeal? Yes, you can appeal, class. You can appeal, but you cannot file a motion for reconsideration. Now, let us say that it was elevated to the RTC. Okay? I would like to be very clear that today it's already a one-step appeal. Remember that. Once the RTC renders a judgment reviewed by the RTC class, the judgment is final, executory, and unappealable. I would like to be very clear. Final, executory, and unappealable. Therefore, sir, what's my remedy? You cannot do Rule 42 anymore for ejectment, for forcible and unlawful detainer, or even summary procedure cases. Do you follow? Now, what is your remedy if you think that the order of the RTC was with grave abuse of discretion amounting to lack or excessive jurisdiction? File a Rule 65, a petition for certiorari. Regular class, a petition for certiorari. Now, the next question is, for that appeal, to stay the judgment, what should the appellant do? File a notice of appeal within the reglementary period, post a supersedeas bond within the reglementary period for the arrears, and deposit the rentals or the occupation of the property in the regional trial court. Failing to continue to pay on a regular monthly basis the rental for the occupation or use of the property, then you will have to surrender possession. The appellant will have to surrender possession. And if you refuse to surrender possession, the court will issue a writ of possession. A final word, class, in ejectment. Please bear in mind that in an ejectment case, the court may preliminarily determine or provisionally determine who is entitled to ownership. Okay? To ownership, to establish who has the right to possess. Okay, class? We are now on the last rule on special civil actions, which is contempt. For purposes of the Preweek, remember this. For direct contempt, it is an act of disobedience in the presence or so near the court or the judge. Kindly take note of that. So if you make a statement, offensive statement in the presence of the judge inside the courtroom, it could be placed on direct contempt. If, for example, class, you recorded the proceedings in court that is in the presence or so near the court or the judge, disrespect or disobedience that disrupts the proceedings because of your recording, unauthorized recording, you'll be liable for direct contempt. Kindly take note. If you made in your pleading statements which are offensive, abusive, not only of the court, but also of the other party, you could be placed on direct contempt. Please bear in mind that in direct contempt, listen to this, that the resolution of the court is summary. There is no notice and hearing. It's summary. That is the nature of direct contempt. While the resolution of the court is summary, and the order holding you on direct contempt is what? Executory. That order could be stayed upon posting of the bond. And the remedy is a certiorari or a prohibition. Always remember that. Because it was swift, it was summary, your remedy is a certiorari or a prohibition. Now, let us look at class about indirect contempt. What about indirect contempt that I would like you to remember? Class, indirect contempt is generally a disrespect or disobedience, violation of a writ, order, or process of the court, or any type of misbehavior of an officer of the court in the performance of his official duties, or in the performance of the transactions of the court, or any statements that may have been said by parties to an action who would sway the decision of the court, who would disrespect the court. That is an example of what? Indirect contempt. It's also possible that there is what? Statement made involving what? A pending case. That is violation of the sub judice rule. That could also fall under what? Indirect contempt. It's also possible, class, that for example, there was a false certification, there is non-compliance with the certificate against forum shopping, Rule 7, Section 5, that will be indirect contempt. But for willful and deliberate forum shopping, that is direct contempt. Please bear that in mind. So if a person, upon a writ or order of the court, has been dispossessed of a property, but he surreptitiously returns to disobey the order of the court, he could be held liable for what? For indirect contempt. Interference with the processes of the court. Non-compliance with the subpoena. That is indirect contempt. Or any act that would tend to impede the administration or obstruct the administration of justice. Or any person who makes representation that is a lawyer, when in fact he is not one. Or any person who, being a lawyer, misrepresents that he has authority, when in fact it was not duly authorized by the client. Or any person, class, who rescues or attempts to rescue a person in the custody of the court or an officer of the court could be liable for indirect contempt. So please bear this in mind. Class, the difference is, again, very simple. Direct contempt in the presence or so near the court or the judge that would disrupt the proceedings. But on indirect contempt, it is what? Violation of a writ, order, or process of the court, and my other examples. Now, class, what is the remedy for indirect contempt? Your remedy for indirect contempt is an appeal. Again, it is also executory, the order. It could be stayed by posting of a bond. Take note. It could be stayed by posting of a bond, but the remedy is an appeal. Now, let me ask you this question. How do you initiate an indirect contempt? Two ways. By the judge, motu proprio, upon a formal charge, requiring the party who has violated a writ, order, or process of the court or has committed act that would obstruct administration of justice to explain. And that is notice and hearing. A formal charge originated from the court, motu proprio. And the second is upon a verified petition filed in court, docketed separately with a certificate against forum shopping, which could be subject of a motion to consolidate with the principal action. And as a final word, class, if a contempt of a quasi-judicial body, if there is no rule in the quasi-judicial body, it could be instituted in the regional trial court of the place where the contempt was acted. was committed.